just okay.
Start the show already. Sheesh.
Hello, all of you fine, wonderful folks. How are all of you today? I hope you're fine. I hope you're ready for a show. Hey, Ketchup, how are you?
I'm good, Jay. How are you?
Oh, I'm good. Boy, the flea bags were on fire last night. That Paint Chips was on, and he pegged us all. That was
Not me and Star. Not me and Star.
Oh yeah, you're safe. You're safe. But no, Jeremy and Megan Fox and myself, we all got pegged. I'm not sure. Was it anyone else? Did Tug get pegged too?
Yep.
Okay, so it's Tug, myself, Jeremy Hales, and then of course Megan Fox all got pegged. But
and Trash Panda.
Oh, Trash Panda got pegged
and
too.
Shara.
Shara got pegged. Oh boy.
Literally everybody but me and Star.
Is Rosalind safe?
I'm pretty sure he got Rosalind too. I'd have to go back to double check, so don't quote me, but I'm pretty sure she got pegged.
I thought Roz was safe from the pegging.
Oh, well, maybe she is.
By Paint Chips.
I could be wrong. But I thought Star and I were the only ones that didn't get pegged.
I'll go back and check and see if Rosalind got pegged as well by Paint Chips. Hi, Allie Riddle. Hi, Faves. Hi, Creason. Hi, TK and Nana's Ranch. Tracy Spencer. How are all of you fine folks? I hope everyone's doing well. Hey, Dwayne, how are you? I hope everyone's doing well. But yeah, it was one heck of a pegging last night.
You guys must be tired.
I know. I sent an email out and asked Jeremy Hales if he wanted to be on my show to talk about this pegging on Saturday. On Saturday afternoon, and he said he might be a little too busy because of all of the pegging he's receiving from Paint Chips, but he said, but B-U-T-T, but capital letters, but
it's understandable.
Send him a link. So I will send Jeremy a link and we'll see if we can get him on Saturday afternoon to talk about the very serious pegging that we all took from Paint Chips. It was hard, and we were taking it.
Oh, these people, I swear.
The goofiest group of people I've ever come across in my life. And I love them. I mean, in my own little way, I love them. Hi, Debbie Webb. How are you, Debbie Webb? And Jay Schrader, how are you? Mama Bear Leah, hello. My four sons. You know what's weird? I'm looking at my StreamYard, and sometimes the numbers, it's really weird. Keep going from, like, right now it says 81, and then just a bit ago it went all the way down to 0, and then it goes back up to 65, and then all the way back to it's really weird today. I can't tell who's here, who's not here, but I can see you're here. Hi, Rainy Days. Peculiar is here, and
hey, Peculiar
is here. I haven't been pegged in years. Let me, you know what? I'll do you a solid. Let me send Paint Chips your way. I will give them an email. I'm going to send Paint Chips your way since you haven't been.
We'll take care of that for you.
That's called just J-Hip doing you a solid. And just remember, in a roundabout way, you asked for it. Good morning, Metal Mom. Oh, listening while I work. Oh, man. Oh, these dummies. Hey, Andy Williams, how are you? Andy Williams and Slinky, how are you? Krusty Witch, hello. Now we're going to move on. I'm going to tell you what, though, folks. At some point in time in the show, I will pause. I will give you a Fleacap. I know everyone wants a Fleacap, but we have a job to do, and that's getting through our Darrell Brooks coverage. All right, because we have a case to go through, a case to cover, a case to indulge ourselves in. And it should be fun. Well, I don't know about fun. It should be a thing. It should be a thing. I don't know. It'll be something. Oh, here we go. Now, this one here is a shorter clip. I'm going to take us off stage here, Ketchup, so we can get the full screen. I'm also going to put the closed caption on here. There we go. I got the volume up. Now, this one here, this is only an hour and 35 minutes long, okay? We're going to go, after this, we're going to start into trial day 1, all right? So this is an hour and 35 minutes. I'm a born and bred Nebraska living in Lewiston. I love listening to you guys. Well, we love that you're here, Jay, and we appreciate it. I'm a born and bred Nebraskan, been here my entire life. Never leave. I never leave my Nebraska unless I'm going, of course, sometimes to Dallas, because a lot of times Rosalind Duke invites Just J Hip down for dinner and lunch, and you know, so I sleep at the foot of the bed, with Honey and Trixie, and the Duke kicks me in the back all night long. I'm like, I wish he was shorter. I wish he was like, I wish he was like the banker. I wish he was shorter, or like
Shizzy,
with his 2-foot legs. That would be so much more comfortable for Just J Hip, but it's not. You know what? I'm so thankful that the Duke is not online. He would be so disappointed in Rosalind for keeping friends like me around.
Oh, I think he's aware.
Hi, Stephen Bear, and hi, Denise. How are you? Thank you for being here again, Faves. By the way, thank you for doing bingo last night. We appreciate you. We're doing bingo again tonight. A couple things before I start this video. I'm going to have to debate on whether or not I do bingo next Thursday, because, well, it's Christmas.
Oh, is that Christmas Eve or Christmas Day?
It's Christmas Day. Now,
okay.
It is available, of course, but I don't know if anyone else is going to be available. I don't know if anyone else is even going to watch. So we'll see. We're going to see, what happens, but possibly I'll try and do it. Maybe we'll do a stream, maybe not. I don't know. But we'll just see how it goes with the 12 bombshells of Christmas going off. It's just, it may not be the thing for us, but we'll see. I'm going to play it by ear. Okay, play it by ear. Oh, Green Flamingo. Remind me, Green Flamingo. You have a couple good videos out there that I saw. Well, I'm probably more than a couple, but I know I've seen 1 or 2 that I really loved. Remind me, Green Flamingo. Actually, send me an email, Green Flamingo, so I can share one of yours on my Saturday show. I will. I do like to pop around, share other people's streams or things that they got coming out. So I do like to do that. So do send me an email, greenflamingo@jjhip@gmail.com, and I will pull up one of your videos. Of course I will. Of course I can. Okay, let's get going on this one. Let me see. Let me get the right one pulled up.
Yeah, that's a good point, Faves. The bar might not be open.
That, yes, there could be several things into that with the bar not being open.
But we could maybe do something else. We have to see.
Will Kensington be open? I don't know. Kensington.
I'm pretty sure Kensington's always open.
It's closed. They closed down Kensington for the holidays. No homeless today. No rugs today. No. Christmas without Jay. Now that's a present. Oh, that's terrible.
Oh, Steven, that's not very nice.
Thanks. Can you time out Steven for like 2 minutes? This is terrible. Time out Steven. He can come back when he's adjusted his attitude a little bit. man. I'm sorry. Oh, you guys are too funny today. Okay, let's start the show here. Let's start the show. Here we go. Joe Brooks is going to want to represent himself. Here we go. Now, his lawyer's talking to him right now, and he's like, "Are you sure you want to do this? I just want to make sure." And he's like, "Yeah, I got this, gang." And he's like, "Okay, well, now the judge is going to ask you some questions. In order to represent yourself, you have to answer the judge's questions." And he's like, "Gang. And so this is what's going on right now." He's going to talk about, he says it's writing skills. You have to be able to show other stuff and everything else. Make sure you can do this and that. He's like, gang, I got this. Don't you worry about a thing. I got this, gang. And as you can see, over on the other side, we got Witch Owl.
Man, looking at his hairline without the fake dreads on, they didn't have a lot to work with when they put those fake dreads on.
No, they didn't have a lot to work with. No, it was a tough one. I'm sorry, Starcasm told me to do it, says Steven. Why wearing a mask if you face a death sentence?
Right.
Thank you, everyone. Please be seated.
Now, here's our judge. Now, this is Judge Darrell, and I have a beef with Judge Darrell, but that's not the beef you...
Court will call State of Wisconsin versus Darrell Brooks, case number 21C.
The beef I have with Judge Darrell is she played kid gloves with Darrell Brooks and read into the record the same stuff over and over again, where she could have just been like, same thing that happened last time, he speaks like an idiot, he's interrupting everybody, he's being a jerk, a total D-bag. She could have just said that, but instead she goes into a total recap of every single thing that occurs. Now, I get it. She's keeping the record clear because chance in hell that this will land on. But at the same time, I think she went a little above and beyond. But I hate to criticize because at the same time, she's doing her job. All right, I'm not a judge. She's doing what she was told. And I even heard in interviews that she reached out to other judges and asked them advice on what to do. So I'm sure she was just making sure she was preserving the record. So there is no way in hell that there's going to be an appeal on this.
Yep.
Survivable appeal.
That's why she did it, yeah.
Yep. So, but it did frustrate me, and a lot of other people were very frustrated with how she did things. But I get why she did it. Very high profile case, probably the biggest case she's going to hear in her lifetime. So I
put yourself in her shoes, having to deal with this douchebag every day.
Exactly. Jay, you are breaking up. I'm breaking up.
Not anymore. Just for a little brief second, like a minute ago. But you're good now.
Okay, I'm all good. And she does have good hair. She
has amazing hair.
Wonder Woman over there. That's like the Megan Fox of judges.
Seriously, she does have like Wonder Woman hair, but better.
Yeah, the Megan Fox of judges. Judge Darrell Fox. Here we go.
CF 1848 may have the appearances, please.
Good afternoon, Your Honor. Sue Opper, Leslie Basie, and Zach Witchell appearing for the state of Wisconsin.
Darrell Brooks appears in person with his attorneys, Anna Keys and Jeremy Perry. Good afternoon.
Right. Good afternoon, everyone.
Back to that.
I'm sorry?
I'm here representing myself pro per.
All right. Thank you, sir. Then we are here so that I can once again address the motion to withdraw that was filed by the defense attorneys.
Did you see the judge? Did you see the lawyer next to him? Like, he's like, he puts his hands up like, whatever, he's going to say something stupid. Here we go. Like the minute he says, I'll represent myself pro per, his lawyer goes, hang on, I'll grab that again here. Well, it's not that important. Let's just move on.
In this case, late last week, I did receive this morning a filing from the defense. It includes the waiver of right to attorney form that appears to have been signed by Mr. Brooks. I want to start with the defense team, because it's still a team right now, Attorney Terry, and I want to get some information from you for the record. So if you could please tell me how many times that you have met with Mr. Brooks since you've been appointed. I'm looking for you to quantify that for me if you can.
I need a moment.
Sure.
They got a calculator out. Like a lot. Can we get an approximate how many times?
How many days into him getting arrested are we now?
We're about a year in. We're about one.
Oh, okay. But nothing's really happened. They've just done
Now
a
he's
couple.
going into trial on the following week. All right. Now this I believe is a Thursday. He's going into trial on Monday. All right. Now the judge will make this very clear. Like you're not getting more time to prepare for your case. Your case is
Right.
prepared. So right now they're just
Chairman,
not figuring
while
out.
they're reviewing that, is the live stream on?
It is.
Okay, the monitors aren't on?
And then as you can see
Not at the moment.
a long time ago, but in the
I can
back,
confirm with them.
I'll circle
Okay,
it.
thank you.
Laura Knighty was also working on the case.
If you want the monitors on so you can
It's
see.
possible, yeah, it's a little easier for us to view Mr. Brooks then.
Did you see that? Laura Knighty's up there.
I see.
Let me know when you have that.
She'll appreciate it.
Yes, it's up, it's a small box, I don't know if there's anything you can do about that, but.
In fact, you can all, when next time you see Laura Knighty, let her know that Just Jay had spotted her at the Darrell Brooks trial and pointed it out. And I love Laura
I'm sure
Knighty.
that I can.
Okay,
Me too. She's hilarious.
While they're looking through their notes, if
She's
you would
still- she's-
confirm that you've complied with victim rights.
She's a far too,
Yes,
too
thank you,
big time
wow.
YouTuber for Just Jay
Thank you.
anymore. She's big time out there.
I know. She's really blown up.
Yeah, she's getting by everybody these days.
Thank you, Your Honor. We can say we've met with him at least 25 times.
25 times.
Thank you.
A lot.
In your meetings with him, have you reviewed the charges that he faces and the penalties and exposure?
Yes.
Good morning, Happy.
Have you discussed
Andy.
with him the nature of the charges?
Yes.
Have you provided Mr. Brooks with any of the pleadings that have been filed in this case?
Thank you, MQ Moss. Thank you so much. 10 gifted Just Straight memberships. I do appreciate that. If you get one of those, thank MQ. They work hard for their money. Thank you so much. Much love. And welcome to the Clown Loser Show, where sometimes we cover what the hell, sometimes a little people watch, sometimes we do a members only stream. And of course, Laura Owens and Darrell Brooks right now. Hi. Thank you. Now, this is going to take us a while to get through Darrell Brooks, but when we finish with Darrell Brooks, we're going to move on and go to the Bradley Yawn trial. We're going to go to Bradley Yawn after this, okay? So, I mean, we're talking a month from now. So it's going to take us a little while. Thank you so much, MQ. I appreciate that. Thank you. Back to it.
Anything that you have not provided him, perhaps by maybe not the jury questionnaires, for example, but would he have gotten all of the other pleadings in this case? Anything that's not confidential?
Everything has been communicated with him.
I
Not
retired.
everything has
Love
been
that.
printed
There we
in
go.
the-
Thank you.
Gang,
What
gang.
about discovery in this case? I'm told, I haven't obviously not seen it all myself, but I'm told it's quite voluminous and that it includes not only paper discovery, meaning printouts of police reports or photographs, but there's a large amount of electronic discovery. Is that all true?
Yeah, that's all true.
Has he been provided with copies of the paper discovery?
Yes.
How have you reviewed with him the electronic discovery?
At a meeting at the jail on our computer in terms of reviewing videos. Not all electronic discovery has been reviewed. There are lots of audio files.
Oh yeah, Phelps, he's quite the loser.
I should say reviewed with Mr. Brooks at the jail.
Thank you. Have you communicated with Mr. Brooks during
You're
the
gonna
course
call
of your
her
representation in writing, either you to him or him to you? I'm not looking for you to divulge any, privileged information, just generally, how have you
Oh,
communicated
Judge
with him?
Audie.
There have been some times in writing.
I said,
Has he written to you at all?
Yes.
Have you had any concerns with his ability to communicate with you either orally or in writing at any point in time during your representation?
I want to answer the court directly, but I'd like to answer this way, is that, and maybe this is not what you're asking, but we are very aware of our obligations in terms of raising any concerns if there were about competency or the ability to communicate. And
I'm not looking for that. No, I'm looking more for your assessment of his literacy and his ability just generally to communicate with you in the English language.
we've not had any problem communicating with Mr. Brooks.
Thank you. It's my understanding that he provided to you or to Attorney Keyes the waiver of right to attorney form that he filed with the court this morning. Is that true?
That was delivered to us via by jail staff this morning.
hi, Lisa.
Thank you. I know that you also filed a case and really a summary of that case with the court. Is there anything you want to put on the record at this hearing regarding that filing?
Only that I think from some of the comments of Mr. Brooks, and I say this with the understanding that
Hey, Emma.
we view him, of course, our motion to withdraw has not been granted. We're still representing him. And it is our clear understanding that it is Mr. Brooks's desire and objective to represent himself in this matter. There were some things at yesterday's hearing that I think maybe seemed inconsistent with that in terms of colloquy with him, and some things that perhaps appeared inconsistent on his written waiver of attorney form. We provided that case law in that context of United States v. Banks with the exchange that has some real similarities to the exchange that happened in court yesterday, where, and this is, if there's a distinction being made in the sense of what part of the Sixth Amendment does Mr. Brooks wish to waive in terms of how he sees himself as appearing in this case as a special appearance, pro per, as he has said, that the context of that with his really quite clear statements throughout yesterday's hearing of where I think he said multiple times that his wish is to represent himself in this matter. We provided that to try and place some of the sovereign citizen language in context where it is maybe not as inconsistent as it may first seem, to support what Mr.
I want to bear in mind one thing. This prior, up to now, this 11 minutes is the most agreeable that most people will find Darrell Brooks. Right? He's quiet, his mouth is closed, and he's not driving everyone batshit crazy. Okay, so this is the most agreeable form of Darrell Brooks. There will also be a point in the trial where he apologizes to the judge for his outburst and says he's going to be on better behavior. That doesn't last long, but he gives it a whirl. He's like, I'm going to give this a try. I'm going to try being nice. I sounds of us life. Good morning. But we'll get there. Mr.
Brooks is saying he wants, and that is to represent himself in this matter.
What I hear you saying is that certainly prior to yesterday's hearing, Mr. Brooks made it very clear to you he wants to represent himself.
That's right. That's why we filed the motion to withdraw.
Has he done or said anything to you that would cause you to change your assessment of his desire?
No.
Thank you.
There's one additional thing from yesterday's hearing that I think I should add to the record.
Go ahead.
There was a lot of back and forth with Mr. Brooks, and it's been reported on in terms of his, and even the way he filled out that form where he crossed out the word understand. And I think on the form he wrote, "I'm informed of that." And yesterday in hearing, repeatedly clarified when asked if he understood things that I'm aware of. In rereading Ferretta and Imani v. Pollard and the case law on this, it actually requires, that the case law requires, and maybe this is all just semantics, but the language in the case law requires that the defendant be made aware of the charges and the penalties and the risks and disadvantages of proceeding by representing himself. And so I just thought I should mention that to the court in terms of what the language of what the case law actually requires is.
Thank you. I would not disagree with your assessment of Ferretta and Imani. Of course, we have a form in Wisconsin that has been approved by the State Forms Committee of the Director of State Courts Office and Court Ops, and there is some.
This actually is somewhat important. Okay. He's pointing out that in the prior day, all right, where Darrell Brooks wants to represent himself, they had a whole hearing about that. And I'm not going to go through that. It's painful, folks. But throughout the entire thing, he keeps saying, I'm aware. He won't say, I understand. He says things like that. What the council is making a very good point of is that in case law, it's been proven fact that you can just be made aware of. You don't actually have to say you understand. All right. So that is what the council is proving at this point in time, just to make a clear record so they can walk away from this case easily without any worries about any sovereign citizen bullshit getting in the way of them walking away from this case. So that's what he's trying to clear the record so they can walk away clearly without any hangups in the future. That's the best I can say.
Specific verbiage that is on there, which in the vast majority of cases, I think, satisfies the parties. But I clearly understand what you're saying, and I don't disagree, but I do thank you for bringing that to my attention. Mr. Brooks, I do have in front of me a waiver of right to attorney form that was electronically filed into the case.
Hey, Mr. Coop, how are you?
Today.
Hi, man, Jack Kingle. Gang, gang.
Coop.
Can I pull it up? Can you acknowledge, sir, that it is before you on the screen?
Yeah, I can see it.
I don't want to make any assumptions, sir, about who filled out this form and how it got to me, so I'd like to ask a few questions about it. I, of course, gave you this form at the end of yesterday's hearing. Hold on a second. That's the live stream. That's the feedback we get because I'm displaying my computer. So give me a second.
This is not me echoing, all right? This is
I
that.
was about to say, don't even do it, Jay.
Ketchup destroying the stream again. Oh
Nope,
my
it's
goodness.
not happening.
I have his original copy that I could place in front of him. It should also be on the share screen. Are you able to see it in front of you as well, or no?
Not at the moment.
I did a test of this yesterday to see if I shared my screen, how it would come up on the live stream, and I thought it was working, but that's all right. I'll stop the share screen. Mr. Brooks, if you want to confirm with me that your attorney has put in front of you the original.
So can you say it again?
Sure. Could you please confirm that your attorney placed in front of you the original waiver of right to attorney form that you filled out?
Yes, right.
You acknowledge, sir, that I provided this form to you at the end of the hearing yesterday.
Yeah, yes.
I filled in certain information on this form regarding the caption at the top. That's the part that's typed. You acknowledge that?
Which part are you referring to?
So the very top of the form is a caption where it says State of Wisconsin versus Darrell E. Brooks, and there's typed written information. I'm telling you, I filled that out. You would agree with that?
Good morning, sons of
I
fun.
didn't see you fill it up.
So when I gave you the form, was that portion of the form filled out with typewritten information?
Yeah.
All right. There's a section further down that says crimes and penalties. Do you see that?
Yeah, I see it.
When I gave you this form yesterday, was that section or both of those sections actually filled out with typewritten information?
Yeah.
And that's the information that's on the form in front of you. Is that correct?
Yep.
If you turn to the second page of that document, there's a signature box. It has a number of lines. Do you see that?
Hi,
Yeah.
Shelly.
And there is one line where it says name printed or typed with the name Darrell E. Brooks typed in. Do you see that?
I see it, but that is not the way my name is.
Sir, do you acknowledge, just listen to me, sir. Do you acknowledge that when you received the form, that printed name was on it?
I recognize that there is a name printed on it. That is not mine.
Sir, the form that you have in front of you which has a lot of other information on it. Did you fill that out?
I filled it out a certain type of way.
Listen to me, sir. Did you provide the handwritten information on this form?
Yes,
I want to confirm the information that you filled out. My understanding, you are 40 years of age. Is that correct?
Yep.
It's also my understanding that you completed 11 years of schooling. Is that correct?
Yep.
You have either a GED or an HSED. Is that correct?
yes,
Do you know which one?
the HSCD. I
Thank
said that yesterday.
Right. I read in other materials that it was a GED. That's why I'm asking you.
I clarified it yesterday that it was the HSCD.
Thank you. It's also my understanding that you are able to read, write, and use the English language. Is that correct?
Yes,
English, as I understand it, is your first and only language. Is that true?
yes,
Further, my understanding, sir, that
Okay, now, this is the one mistake the judge made. All right. This is a big mistake because she asked if the only language he speaks is English. That's his main and only language, but he also speaks stupid. All right. She didn't clarify to make sure he also spoke stupid. He does speak that language as well. That is there. It's on the record, or it should have been on the record. All right. He also speaks idiot. All right. And soft idiot. All right. He speaks a lot of languages, actually, but they do all revolve around the English language. So I just want to put that out there.
It does seem like stupid is his first language, though.
Yes, you see, that's what I was going to say. If there's going to be an appeal, that might be his best luck, to go back to this very point where, he confirmed he spoke English as his first language. That's just going to be a problem. But here we go.
you are not currently receiving treatment for a mental or emotional problem. Is that true?
not currently,
Is that true?
not currently.
Did you hear my question?
Yeah, I heard it.
Is it true that you are not currently receiving treatment for a mental or emotional problem?
No.
It's not true.
Say it again.
Is it true that you are not currently receiving treatment for a mental or emotional problem?
Yeah, that's true.
You also have checked that in the past you have received treatment for mental or emotional problems. Is that true?
Yes,
Further, my understanding, sir, that you have not had any alcohol, medications, or drugs within the last 24 hours. Is that true?
yes,
It's also my understanding, based upon how this form was filled out, that you do not have any physical or psychological disability that may affect your ability to be informed what is happening in court or communicate your position or views on the case to the court. Is that true?
yes,
We talked a little bit about this yesterday. You graduated with an HSED, as we talked about, right?
Thank you, Faves.
You've been able to read the various documents that have been provided to you in this case. Is that true?
Yeah.
You're able to write. Is that correct?
Hey, Faves, if you could throw Green Flamingo link in the chat, I appreciate that.
Let's go down to the next section, sir, where it says, I am informed that I have been charged with the following crimes that carry the following penalties. Do you see that section?
Yeah.
I want to advise you of the following. I want you to listen to me.
And thank you.
You are charged with 6 counts of first-degree intentional homicide, use of a dangerous weapon. Each one of these counts is a Class A felony,
Thank you.
punishable by life in prison, plus an additional 5 years for each count. Are you aware of that, sir?
I'm informed, yes.
You are also charged with 61 counts of first-degree recklessly endangering safety.
61
This-
counts.
Each one of these offenses is a Class F felony. Imprisonment of not more than 12 and a half years plus 5 years for the enhancer for use of a dangerous weapon for each count if convicted. And you are aware of that, sir.
Yes, I'm informed of that, yes.
There are also 6 counts of hit and run resulting in death. These are Class D felonies. Imprisonment of not more than 25 years for each count. And you are aware of that as well.
I am informed, yes. I was under the impression that it was a certain type of way in the wording.
Sir, you are also charged with 2 counts of felony bail jumping. These are Class H felonies. And upon conviction, you may be imprisoned for not more than 6 years for each count. Are you aware of that?
I am informed.
And then there are 2 counts of misdemeanor battery. Those are Class A misdemeanors, and upon conviction, you may be in prison for not more than 9 months. Are you aware of that?
I am informed.
This rocking back and forth, this is Darrell Brooks wanting to get through this. All right. This is boredom. All right. That's what this is.
Have you been informed, sir, regarding the total exposure if convicted of all counts as charged across these 77 counts?
I am informed, yes.
Are you informed, sir, that as to the intentional homicide charges, use of a dangerous weapon, that if convicted, you could be sentenced to 6 life sentences consecutive to one another?
I'm informed.
Do you understand? Strike that. Are you informed, sir, that you could be sentenced consecutively on each one of the counts for which you are convicted?
I'm informed.
That's true.
For the first degree reckless and endangering
Yeah,
safety charges,
shit.
without even the enhancer, are you informed that the maximum exposure is 762.5 years?
I'm informed.
Are you informed that when adding the enhancer, it adds an additional 305 years?
I'm informed.
Are you informed that the hit and run resulting in death charges carry an exposure of 150 years?
I'm informed.
Are you informed that the felony bail jumpings carry an exposure of 12 years?
I'm informed.
Are you informed, sir, that the exposure for the 2 Class A misdemeanors is 18 months?
I'm informed.
Are you informed, sir, that all of the charges stem from an incident that is alleged to have occurred on November 21 of 2021 in the city of Waukesha?
I want to point something out, all right, because I understand this trial was from a while ago. Having a little reflection into what somebody did that was terrible, all right, is sometimes good in life to have a little bit of reflection on this man's terrible deeds that caused the lives of 6 people, ruined the lives of hundreds of people, actually, maybe thousands, because there's family members that are still dealing with the aftermath of what this individual did. All right. Now, I have a lot of insight into this case because I watched this over and over, every single portion of this case that I could grab my hands on. All right. That's the reason I'm sharing it with you. All right. And I'll try and give you as much insight as possible. The reason I'm showing this right now, all right, is because when this ends, you're going to see 2 lawyers escape this courtroom faster than any other lawyer. I mean, it's almost like they zoomed out of there without even seeing them. All right. It's the fastest I've ever seen anyone escape from a courtroom. All right.
Yeah, and he affected so many people that day, way more than the people that he hurt. There were so many people there that saw what he did. It was, I mean, that day, it will never be the same. You know, the parade will never be the same.
And it's not, and the other point of it, it didn't have to happen.
No.
This all was because he met up with Erica Patterson, and then he abused her again. Then he thought the cops were going to come after him for abusing her again, and he knew he was going to face serious jail time, prison time for abusing her again. So, as a result of that, might as well run over a parade. All right? I mean, it's insane. All right? The level of evil that is here in Darrell Brooks, and he doesn't give a shit about it. He doesn't care. And you'll see it throughout the whole trial, and that's why we're sharing it. Because I think it's important. It was important to me, and that's why I'm sharing it. And, it may not be like, this huge, awesome, revealing show. It's important to me. All right. And that's what matters. I think it's important to Ketchup. I think Ketchup wants to see it. And hopefully you do as well. But yes, he is a total D-bag. And we'll get there. It's gonna be a watch. Let's put it that way. It's gonna be a watch. I'm not sure what kind of a watch, but a watch.
I don't see that on the sheet.
Sir, did you hear what I said?
I thought I was following the sheet. That's why I'm looking.
Sir, did you hear what I said?
I did not hear what you said.
Sir, are you informed that all of the charges stemmed from conduct that is alleged to have been committed by you on November 21 of 2021 in the city of Waukesha?
I'm informed.
Are you further informed that all of this conduct primarily relates to what has been referred to as the Waukesha parade incident?
They word it as a different way. They call it an attack.
I don't know who they is, and I don't frankly care. Listen to my question, sir. Did you hear what I just asked you?
No, I'm not informed of that. This has never been referred to.
Sir, I am advising you that your conduct that is spelled out in the second amended criminal complaint, which this court provided you with yesterday, accuses you of committing multiple offenses during the Waukesha Christmas parade. Did you hear me say that?
Yeah, sir. Thank you for correcting the language.
The next part of the form, sir, and I will return to it, is entitled, I understand I have the right to. Do you see that?
Mine says I am informed.
Sir, the form, listen to my question. Do you see the section of the form that is entitled, I understand I have the right to?
Mine says I am informed.
You're not listening to me, sir. I'll get to that. But the form, the state form, has a section that is titled, I understand I have the right to. Do you see that?
Yeah, I see it.
All right. You changed the word I understand to I am informed. Is that true?
Yes.
I'm going to advise you of the following. I want you to just listen. Sir, you have the right to have an attorney represent you at all stages of the proceedings. You have the right to have an attorney appointed for you by the state public defender if you do not have the money to hire an attorney. You have the right to hire your own attorney at your own expense. You have the right to ask the court to review a determination by the state public defender that you are not indigent and able to hire your own attorney. You also have the right to ask the court to find you indigent or partially indigent and appoint a court-appointed attorney for you at county expense if you have been found not eligible for a public defender. You also have the right to represent yourself and act as your own attorney. Did you hear me just now, sir?
Yeah.
There is a line underneath those advisements that says, check this box if you read and understand the above. On the form that I have, the word understand is changed to am informed of. Is that true?
Yes.
The box is checked. Is that also true?
Yes.
Did you check this box?
Yes.
Okay. I have to point something out here because I've seen it come up in the chat. Darrell Brooks, although he is an idiot, he's not actually an idiot in terms of he's very manipulative. Right now, he has two lawyers sitting next to him. This is what's called, feeling out the room. He wants to see how far he can go with this judge. He's testing her. All right. So how much of a problem can I cause without getting in trouble? Right. So he is testing her with just being basically, making it a struggle to get through very simple questions. That's why he wants to test her on this, just to see what he might get away with in court. All right, so this is a testing thing. He's waiting to see if his attorney at any point is going to be like, you have to do this, you have to do that. All right. And this is the same type of behavior that you see out of a lot of other people. I will give you an example. Look at Paint Chips. All right. This is an example. Paint Chips likes to attack women. Megan Fox. All right. George. Rosalind Duke. Trash Panda. All right. Does Paint Chips like to attack men? No, he does not like to. Paint Chips wants nothing to do with just J-Hip. All right. Wants nothing to do really with talk. All right. No. All right. He likes to attack women. All right. Darrell Brooks is the same way. He likes to attack women. All right. And that's his thing. He feels control over women. But anytime a male is in the room, like if this was a male judge, this would have gone in a completely different direction, I assure you. But because it's a female judge, Darrell Brooks feels like he has to show some sort of dominance any way he can. He has to be uncooperative. That is what's going on here. He wants to test the waters to see what he can get away with. That's why I'm sharing that. Okay, now we're going to move on. Hi, Renee's here. Hi, Renee.
I'm surprised he didn't change his last name to Obey.
God, no. That would be amazing. It's Darrell Obey.
The next section
like
of this
isn't
form is
Yeah,
titled,
like all the others.
I understand an attorney would.
Isn't that in the SOBSIC
However, on the
handbook?
form that I have, the word understand is changed to am informed. Do you see this section of the form, sir?
Yep.
Did you change the word understand to am informed?
Yes, I did.
I'm going to advise you of the following. I want you to just listen. You are advised that an attorney would represent you and speak on your behalf in court.
Me too.
An attorney would also advise you about your legal rights and options. An attorney would explain and assist you with legal and court procedures. An attorney would help you negotiate a settlement of your case with the district attorney. An attorney would investigate and explore possible defenses to the charges against you that may or may not be readily apparent to you. An attorney would prepare and conduct a defense on your behalf at any motion hearing or trial. An attorney would file motions on issues of evidence, testimony, and procedures of the police. An attorney would assist you at sentencing if you are convicted of any crime. An attorney would also file an appeal if requested. Did you hear me just now, sir?
Yeah, I heard you.
On the form that I have, there is a line underneath that says, check this box if you have read and understand the above. The word understand has been crossed out and changed to am informed of. Do you see that?
Yep.
The box is not checked. Do you see that?
Yep.
Was that an oversight?
No, it's a reason.
I'm sorry, I didn't understand what you just said.
There is a reason.
Do you sir, I advised you of what an attorney would do. Are you informed of what an attorney would do for you?
Yes,
Why did you not check this box?
because it is my understanding that representing myself pro per, I can have standby counsel. So that, in a sense, is why that box specifically is not checked.
That is not a correct statement of the law, sir. Standby counsel is not for the benefit of a defendant, it's for the benefit of the court.
Either way, it's still allowed for me to have.
Have you been advised, sir, that the public defender's office is not able to perform standby counsel duties?
No, I have not been advised that.
This is true. In some states, you are allowed to have standby counsel. However, not in Wisconsin. This is a flaw for Darrell Brooks. He can't have standby counsel. I will cover another case where an individual does have standby counsel who does represent himself as well. But not here. Darrell Brooks is wrong. He can't have standby counsel. It's either him or a lawyer. He doesn't get a public defender assistant. All right. Now, he could have standby counsel if he was to pay for standby counsel, but you can't have public assisted standby counsel. The state does not pay for you to have a babysitter. They pay for just straight hip to have a babysitter, not for you to have a baby. No, oh wait, no. No, they don't pay for you to have an assistant. All right, basically. Yeah, you don't get an assistant. That's not how this works. And basically, what Darrell's looking for is someone to, go get his paperwork and get him a coffee. Yep, no, that's not quite how this works. But okay, carry on, Darrell. It's going well.
There is a rule that was promulgated by the Public Defender Board in Wisconsin that prohibits public defenders from acting in the capacity of standby counsel. Did you hear me advise you of that just now?
Yeah, I heard you say it. What is it called?
You referenced standby counsel, sir. I'm advising you that the Public Defender's Office is not able to act in that capacity. Did you hear what I just said?
I heard what you just said, and I asked you a question. Is that somewhere that I can find out about that information? Some type of law or some type of
Thingy.
So it's admin code.
We're going to get a bit of feedback, but I'm going to put it up on my screen, which the parties will be able to see.
We're going to get a little bit of feedback. This could be caused by ketchup. Ketchup's causing some feedback.
Sir, can you see what's before you on the screen?
Yep.
This is an administrative code provision, chapter PD5, adversary representation. Direct your attention to PD 5.03, prohibition against acting as standby counsel. Sub 1, no SPD attorney may act as standby counsel in any case. Sub 2, this prohibition applies whether or not the SPD attorney was originally providing adversary representation in this case. You see that, sir?
Yeah, I see it.
Hi, Bonnie.
I'm going to take that down.
Horace Happy says, hi, Beanie.
This court, sir, you should be advised, would not be appointing attorneys Perry and Keys to represent you or to act, is a better way of saying it, as standby counsel in this case. Did you hear what I said?
Yes, and I didn't ask that. I didn't ask for them.
I'm not asking if you asked that, sir. I'm giving you advisements right now that you need to listen to. This court would also not appoint standby counsel in this case. Did you hear me say that?
That's fine.
This court is further advising you, sir, that this trial will start next Monday, October 3rd. Did you hear me say that?
I heard you say it, but I object to that. And I object on the grounds that, are you making a judicial determination of that when you haven't even decided the issue while we're here?
Sir, I'm further going to advise you that at this late stage in the proceedings, which is frankly beyond the 11th hour, which is what the case law references, we are frankly at 11:58.
Yep.
This court will not appoint any other attorney to act as standby counsel if this court grants your request to represent yourself. Did you hear me say that, sir?
Is that the answer to the question?
Sir, did you hear me just now?
Is that the answer to the question?
This is not a question and answer session, sir. I'm giving you certain advisements. Did you hear me advise you just now?
Did you hear the question I asked? Because it sounds like a
Mr. Brooks, we'll move on. You are advised
You are
that,
arresting the
Mr. Brooks, you are advised that this court will not appoint standby counsel.
Okay, you said
There
that,
are
but you
a number
didn't
of reasons which I will advise you make it impractical.
You're not
This
answering
trial
the
is
question,
scheduled.
Your Honor.
Mr. Brooks, do not interrupt.
That is a arrest
Mr.
judgment
Brooks.
if you don't answer the question.
The judge is not here to answer your questions. You are here to answer her questions, okay? She is making things very clear that come Monday, right, trial starts. If you dismiss these two lawyers, see you Monday on your own. Be prepared, jackass. We're going to have fun. It'll be a good time, right? But be prepared. Also, if we could get Rogue Mama more than 718 subscribers, let's do that. Toss a link in the chat to Rogue Mama.
Already did.
Oh, there
And so did Faves. Jinx, Faves. Jinx.
So did Faves. Thank you, Faves.
You owe me a Coke.
Both
And not the kind Gabe likes. The,
yeah,
the soda.
You don't want to snort your Coca-Cola, all right? No. We're just talking about regular Coca-Cola, not the Gabe Coca-Cola. Hi, let's do this, Julia. How are you? All right, now I just wanted to point that out, that this is when he's going to start to get a little bit agitated because he's going to find out that court's going forward. Oh, we're doing this. Yep, here we go.
So we are here, Mr. Brooks, we are here because you want to represent yourself.
Yeah, but I didn't file the motion.
That's not relevant, sir. The motion is before me, and I'm going to address it. Stop talking over me, Mr. Brooks.
Just merely asking.
I need to get through the advisement.
And I would like to know the answer to the question.
You are being difficult. You are
I'm
not
sorry,
listening.
Holder.
You are trying to interject irrelevant factors for this court.
It has
So
merit.
stop.
It's not irrelevant.
Stop.
I have a
Mr.
constitutional
Brooks,
right
I'm
to be able
going
to
to
ask questions.
continue. Please stop talking.
So it is a arrested judgment.
Mr. Brooks,
And just so you know, Holder, this isn't the only, in case you haven't seen the show before, this isn't all I do. I cover this a couple of days a week. I'm going to get through this, but I do other court cases with the What the Hell's case, Laura Owens case, and then also we do people watching members only streams. This isn't the only thing I do. I do this for my own personal interest because, once again, it was a very important part of my life as I was heavily invested in this case. So that's why I'm covering it now. I didn't have a YouTube channel when this took place. So here we go.
the case law makes very clear you can't waive your right to an attorney.
No, Robert.
Let me rephrase that. The case law makes clear you cannot act as your own attorney, right? Exercise your right of self-representation while simultaneously exercising the right to counsel. Did you hear me say that?
Yes, I heard you say that, but that wasn't what I was attempting to do. That was the whole reason why I said it was filled out, his form was filled out for a specific reason, the way that it was.
Sir, I'm not going to entertain a request for whether it be called standby counsel, hybrid
That's not what I'm talking
representation.
about.
Your attorneys have told me you want to represent yourself. That is why we are having this hearing here today. The next section of this form is entitled, I understand that if I represent myself, but on my copy, the copy e-filed in this case, it says, I am informed that if I represent myself. Do you see that section, sir?
The section I'd be referring to.
The section that is labeled, I understand that if I represent myself, but the word understand has been changed to am informed. It's on page 2.
This paper's got shuffled up page.
Let me know when he has the correct page in front of him.
Okay, he's got it.
Thank you. Do you see that section, sir?
Now, what section were you referring to?
The section that says, I understand that if I represent myself, but the word understand is scratched out and it now reads, I am informed that if I represent myself. It's on page 2. Do you see that?
Yes, I do.
He
You are
can't
advised, sir, that
understand.
the judge, that's me, cannot be your attorney and cannot give you any legal advice. You are further advised that the district attorney cannot be your attorney and cannot give you legal advice. You are further advised that the judge, district attorney, and court personnel are not required to explain court procedures or the law. You are further advised that the judge cannot treat you any differently because you do not have an attorney. You are further advised that you will be required to follow all legal rules and procedures that an attorney would have to follow in court,
No.
and that it may be difficult for you to challenge evidence presented by the district attorney if your case goes to trial. You are further advised that it may be difficult for you to present evidence. You are further advised that if you want to testify, you must be sworn as a witness and answer questions from the district attorney. You are further advised that it may be difficult for you to do a good job as your own attorney. Did you hear the advisement that I just read to you, sir?
Yeah, I heard.
You are further advised, sir, that acting as your own attorney may be very challenging.
He did not have a defense. All right. His defense was, I wasn't driving the car. The car malfunctioned. Mental illness. We could go on and on. It was a roller coaster of defenses. Nobody really knows. Can he even be charged for a crime? I mean, the prosecutor, can the state of Wisconsin prosecute me? And who is the state of Wisconsin? Oh, goodness. This goes on and on. We don't want to even talk about defenses yet. But I do know this. Growing up, he had to eat buggy cereal. Buggy cereal comes into play. He did have bugs in his cereal. Buggy cereal.
Disgusting.
Yeah, he had to eat buggy cereal. The buggy cereal. Yeah, the buggy stuff. And in the end, what this all comes down to is this is one person's fault. Erica Patterson. Apparently, it was all Erica Patterson's fault. See, it was her fault. He ran her over with the same SUV 1 week prior. It was her fault that he ran through an entire parade, destroying people's lives. It's all Erica Patterson's fault. All right, let's keep that in mind.
Clearly.
It's obvious. It's obvious.
It's just that simple.
You'll see. This is mind-boggling. You'll see this when we get to trial. How many times he says it's obvious. It's mind-boggling. Oh boy. Terribly.
You would be required to participate in jury selection, including exercising preemptory strikes. It may be difficult for you to raise the issue of strikes for cause. At trial, it may be difficult for you to raise objections, both when to make them and how to make them, whether it be as it relates to the admission of evidence or the testimony of witnesses.
You won't have any problem with
Other obstacles that you will face include applying the rules of evidence, understanding and applying the rules of trial procedure. These are things that are spelled out in the Wisconsin statutes. They're the law. You may face challenges when it comes to jury instructions, including when or whether to ask
Yes.
for jury instructions on lesser included offenses. Did you hear me
Come on,
advise
Anna.
you of these challenges,
Yeah.
sir?
I did hear you advise me of them. I don't see them as challenges, Your Honor.
I
At all.
don't see these
The court must also
challenges.
advise you that I can make no guarantees about your access to legal materials while in the jail. Did you hear me advise you of that?
Yes, I did.
I don't see this as a challenge, Your Honor. No, no, not at all.
Right?
Gang, gang.
You may even find, sir, that if I allow you and honor your request to represent yourself, that once this trial starts, you may find it difficult and may even express a desire to change your mind. In other words, you may regret the decision that you make. I'm advising you, sir, that at that point, it would be challenging for this court to reinstate your right to an attorney. Did you hear me advise you of that, sir? Did you hear me, sir? Mr. Brooks, did you hear me?
Yeah, I heard you.
Once,
Can I ask why would it be challenging?
sir, once, let me continue. I want to advise you the following.
Why might it be challenging? Let me see. When you issue a subpoena and you want to contact people to come to court as a witness, of course, the state is going to assist him. This becomes a problem later on because Darrell's a D-bag. Right? At the same time, finally, the judge is like, then you can just contact your own witnesses and have them show up on your own. He's like, how am I going to do that? And she's like, you can call them on the phone. I imagine how that will go. Hey, it's the murderer caller, Darrell Brooks. I'm going to need you in court tomorrow at 8 a.m. So, you might want to work with the prosecuting team a little bit to have them make sure that your witnesses arrive on time. But instead, D-bag Darrell, he can't do that. He has to be a major douche about it and whine and cry and act like, well, I can't do that. And it's like, work with the prosecutors. Well, no, because I want everyone here, everyone on my terms. Oh, he's such a D-bag. But that's why we do that's why we're following the case.
When a person represents themselves, they are acting as their own attorney. Did you hear me say that?
Yeah, I don't agree with that.
The case law says that rescinding a waiver of an attorney is no different than a motion seeking the substitution of an attorney. That is why this court is advising you it would be challenging for this court. I didn't say impossible, it would be challenging. There is significant case law on substitution of counsel and it falling within the discretion of the court. There's criteria discussed in cases such as State versus Lomax, State versus Boyd. There is case law that discuss 11th hour requests, which are generally frowned upon as delay tactics. The court would consider things like the impact on the court's general responsibilities for the prudent administration of justice. The court would consider whether requests like that interfere with the administration of justice, the impact to the court's docket in general, and other considerations, including
let's
the
get
significant amount of time, resources,
dose reality,
preparation that the court, the parties, even the clerk of court and the sheriff's department have put together to bring this case to trial in October of this year. Did you hear me advise you of all of these things, sir?
Yes.
There's a reason I'm telling you, sir, about some of these challenges and difficulties, and that is because I want you to know that waiving your right to an attorney does not mean the trial is delayed. Did you hear me say that?
That's not my reason for wanting to represent myself, Robert. It had nothing to do with delaying the trial.
So you don't want to delay the trial, correct?
That's not what I said. I said that the decision to represent myself, Robert, had nothing to do with a delay tactic. I think I'm very clear with what I said.
Well, I want to be clear. I understand you, sir. If it's not a delay tactic, I take that as you're not requesting an adjournment of the trial. Is that true?
That's not what I said.
Are you requesting an adjournment of this trial?
I can't logically make that decision until you make a judicial determination. Why would I answer that question right now at this point when I still don't know what's been decided yet?
So here's the important takeaway, in my humble opinion, sir. You are being advised that I am not going to adjourn the trial that is scheduled to start next week. Did you hear me say that?
I heard you say that. And I still can't logically answer what you are asking me because a decision has not been reached.
She's
So
freaking
what you need to
telling
understand
you.
is that the case law makes it very clear you have the absolute right to represent yourself. That is protected by the U.S. and the Wisconsin constitutions. Did you hear me say that?
I know that.
You have the absolute right to have an attorney represent you. That is protected by the U.S. and the Wisconsin constitutions. Did you hear me say that?
I'm aware of that as well.
It is my understanding, sir, that based upon the motion that was filed, the waiver of attorney form that was filed, and the proceedings that have been held over the course of the last 2 days, you wish to represent yourself.
I wish to represent myself pro per, but I do not wish that my entire Sixth Amendment right not be honored. I essentially would only be agreeing to the part where I want to represent myself. Just that stipulation of my Sixth Amendment and no other stipulation of my Sixth Amendment.
Your Sixth Amendment right to counsel is pretty straightforward, sir. You have the right to an attorney. You have the right to represent yourself. Those two things don't always go hand in hand. Never go hand in hand. Sir, you have raised a phrase throughout the last 2 days that has very specific meaning to this court, and I believe to you as well. You have used the phrase in pro per. That is a shorthand way of saying in propria persona. That comes from the Latin phrase, which means in one's own proper person, also referred to as pro per or pro se. I presume that when you use that word, you are doing so intentionally. I told you the Latin phrase that it comes from, or the meaning. In a court of law, it has a specific meaning, and it is used when a person represents himself or herself without a lawyer, meaning without the assistance of counsel, without the assistance of an attorney. When you use that word, sir, it is no different from the phrase pro se. The use of that phrase by you, sir, is a clear indication to this court that you want to represent yourself without the assistance of an attorney. Did you hear me advise you of this just now, sir?
Yes, and I'm aware of that same definition by the Black's Law Dictionary.
Let's go back to the form, sir. We went through this section about what it would mean to represent yourself and what a judge cannot do, what a DA can't do. And then I further went over many of the challenges and obstacles you would face underneath the various statements on this form. There's a statement that on the form reads, check this box if you have read and understand the above. On the form that's been submitted to the court, it reads, check this box if you have read and am informed of the above. Do you see that?
Yeah, I see it.
The box has a check mark. Did you place that there, sir?
Yes, I did.
Sir, it appears to me that you read through this form very carefully. Is that true?
Yes.
You clearly changed words on the form, right?
This is not actually true, Peculiar. She's not trying to talk him out of it. She's trying to make sure that as she moves forward, this is what he wants. She has to make a very clear record that this is what he wants. All right? So that's why she's doing this. She's not trying to talk him out of it because she knows his mind's made up. He's milked this dry. All right? These two lawyers have done a lot of legwork for him over the prior year. Okay? He has boxes and boxes of stuff. And these lawyers, in my opinion, has made it very clear to him. You have a plea deal on the shelf, or we can go to trial based on X, Y, and Z. We can say the vehicle malfunctioned, not going to work. We can say, you were having a mental deal, probably not going to work. They've given him his options. He knows his options aren't good. So going pro se at this point in time is his best move because he wants to cause a mistrial. All right. He wants to go in, cause major disruptions, be a jackass. This is his goal. He knows that. However, he's struggling just to get to the point where he gets to represent himself. All right. We're struggling there. He should be making this very easy on the judge, but still, he wants to try and cause a mistrial any way, shape, or form he can, even if it's in this portion. All right, once again, there it is. Jay or Mods, I need your help, please. I'm getting ready to mail a card for Lady T's son. His name is Michael. Yes, his name is Michael. Michael, yes, there you go. Cynthia, his name is Michael. Michael. There you go. There you go. I want to answer that.
And I think she wants to make sure it's clear to him she's not going to postpone the trial.
Yes, she is making every point. I mean, she wants to make things very clear to Jackass how things are going to go going forward. Oh my God, Faves just doxed me. She doxed me. Faves.
Good job, Faves.
Faves doxed me right in the comment section. She doxed me.
Do it again.
Oh no. Patience is here right now. He's trying to peg me. This is terrible. What Faves has done to just J Hip. I'm being pegged right now. This is terrible. No, Patience, no.
Spam the chat with Jay's address.
Stop it, Grand Canyon. Stop it, Hot Dog Bun. Stop it. Stop. Man. We're going to continue on with this.
Yes, for a reason.
It appears to me you did not have any difficulty reading the form and being aware of the contents.
Yep,
Is that also
the
true?
back door.
It's true to an extent.
Don't tell
Yeah,
Patience.
please elaborate first.
Don't
on one of
tell
them. That was the only
Patience.
thing that I had a question of.
Sir, I cannot give you legal advice. What I can tell you is you are required, if you represent yourself, to follow the rules of evidence, the rules of procedure that are spelled out in the Wisconsin statutes, no differently than if you were an attorney.
If I was a licensed attorney, which I'm not, which means that would be pro se and not pro per.
Sir, they mean the same thing. I don't frankly care what you call them. The terminology you use has the same effect. You either have an attorney or you do not. Did you hear me say that?
I'm aware of that.
Underneath that last checkbox, there is a paragraph that reads as follows. I am making this decision to represent myself knowingly and voluntarily. No one has made any promises or threats to me, and no one has used any influence, pressure, or force of any kind to get me to not ask for an attorney. No one has told me I should not ask for an attorney to represent me. Do you see that?
Where it says I am informed of the court process involved in my case, that part. The top part.
Underneath the last checkbox that we went
See it?
through.
I see it.
You see it?
Yep.
Remember reading it?
Yeah, I see it.
There's another paragraph, and it appears to me that you read it and that you changed the word understand to am informed of or on. Do you see that?
Yep.
It says, I have read or have had read to me this entire document. I've truthfully answered and am informed on all portions of this document. I'm informed of the court process involved in my case so that I can adequately represent myself. I want to represent myself. There's a handwritten notation. I do not give up my right to assistance of counsel. Will explain reason. All rights reserved, and there's a signature. You see all of that, sir.
Yes.
You signed this document, sir?
In my true name, yes.
In my true name.
Sir, anyone make any threats or force you in any way to sign this document?
Nope.
Gang, gang.
Anyone make any promises to you in exchange for signing this document?
No.
Gang, gang.
You understand, sir, that by signing this document and presenting it to the court, you're asking me to accept your waiver of the right to an attorney.
Stop doxing me,
Just
Mom.
so I'm clear. That would be essentially just that part of my Sixth Amendment, correct?
The right to an attorney, yes.
Just that part.
We don't know his true name.
We are just talking about the right to an attorney, sir.
So essentially the rest of my Sixth Amendment right is preserved.
It's not the all caps
That is
thing.
correct.
It's not the all caps.
Thank you for clarification.
Sir, do you wish to waive your right to an attorney?
Yes.
Anyone make any threats or force you in any way to waive your right to an attorney?
No.
Anyone make any promises to you in exchange for you waiving your right to an attorney?
No.
You understand, sir, that means attorneys Keys and attorney Perry will be discharged from this case.
Terrible.
I'm a yes.
You are aware that means they will be discharged from representing you.
Yes.
You are
I
aware
swear that lady
won't
attorney of
tell you
his
that
has
at all
been writing in her
after that
legal
decision is
pad,
made.
please let
Yes.
me off this case. Please let me off this case the whole time. Like, please,
Wow.
like, the whole sheet is filled with that. Like,
Meanwhile,
over.
all the prosecutors over here are playing freaking Candy Crush.
Yeah. Solitaire. They're like, this is dumb. Waste of time.
You have to remember, this is like 5 years ago. So they're all playing Candy Crush. It's just like, look, Dummy's going to do his thing. This will be delightful.
Maybe they're playing a round of spades. That would be amazing.
They got their cards out. They got hangman going on. One of them's doing a word find.
Color by numbers.
Sorry, okay, I gotta get back to the show.
Do you believe you are making the decision to represent yourself knowingly and voluntarily?
Tick, tick, tock.
Yes.
Do you believe you are fully informed about the advantages of having an attorney represent you?
Repeat that again.
Do you believe you are fully informed about the advantages of having an attorney, someone licensed to practice law in the state of Wisconsin, represent you?
Fully informed. Yes.
Do you believe you are fully informed of the disadvantages and challenges of
Yeah.
representing yourself and acting as your own attorney?
Yes, I am informed.
No worries, Venom. That sounds fun.
I went through this a little bit, sir. And while I know you have not asked for an adjournment, I want to.
Now, Ketchup, I'm
Yeah.
gonna let this play. I'm gonna mute myself. Just JJ muted. I'm gonna mute myself while I get some more ice and purple drink. I'll be back in 4 minutes, but I'm gonna let this play. Chat, entertain yourselves. Entertain yourselves, chat, but behave. Behave. I will be listening in, and I'm gonna double check on this chat and I'm gonna make sure you behave. I will be
All right. Don't forget to shut off the bidet when you're done.
Yeah, that's just well, that's I gotta wash my hands first in the minute. Dummy said minutes. Stop it! I keep thinking back to when Dummy said such a dumb thing. It's like you say one stupid thing and it will last with me for a long freaking time. So she says bit it one time and it will last with me forever. I mean, forever. It will be bit it to me.
Same.
These dummies don't understand. I find one little thing and it will last with me forever. I can't. Okay, I'll be right back. Here we go. Let me hit the play button.
Make a few things clear if I haven't already. This court feels compelled to advise you in advance of a final determination by the court that this trial needs to take place in October of 2022 due to significant steps to secure a jury. This includes the extra jury pool. By that, I mean initially summoning approximately 1,600 qualified jurors, setting out what we call the initial qualification questionnaire, followed by a case-specific jury questionnaire sent to the vast majority of those 1,600 individuals. In addition, this trial was scheduled 6 months and 22 days. Will be 6 months and 22 days on October 3rd, roughly 6.5 months. It was scheduled on March 11th. We've had significant litigation to date, including a motion to change venue, a motion to adjourn. We've conducted significant hearings regarding the jury selection process. This court heard and decided a motion limiting other acts. This court dismissed 6 counts upon the motion of your attorneys. This court set aside 1 month in October of this year to try this case. The Sheriff's Department has set aside this time. There's extra personnel that's been required from the clerk of court's office, the Sheriff's Department, just due to the high publicity of the case, the number of people involved, etc. Did you hear me advise you of this?
Yes.
Knowing all of this, is it still your desire to waive your right to an attorney?
Yes.
Attorney Perry, anything you want to add to what I've questioned Mr. Brooks on at this time, or any other information you think I should know?
We will promptly give Mr. Brooks preparations that we've done for trial. We'll have delivered to him, and I understand that the jail is going to be working to make electronic discovery reviewable for him and taking all those steps.
From the state, anything you want to add to the record at this point, Attorney Opper?
Yes, Your Honor, thank you. There's a couple of points, please, if you could indulge me here for a minute. The court has certainly been very thorough. There's just a few things that I would like that you could perhaps drill down on just a tad bit more. My concern is on the form that you've just spent extensive time going through with Mr. Brooks. There's indication at the very, very top of it, and again, in the middle part, suggesting that Mr. Brooks has the right to an attorney at any time of the proceedings or any time during the proceedings. You have been very clear here with him that that's not absolute. So I just would like him to be advised that he can't flip-flop. He can't get into the trial and decide on day one he wants a lawyer and then change his mind back and change his mind back again. I think he should be advised of that, because the form does say I may change my mind at any time on the second sentence of the form. And that needs to be made abundantly clear to Mr. Brooks that that's, I believe this form is used largely in the pre-trial capacity and not the week before trial. So I would like the court to please advise him of that. Do you want to do these one at a time, or do you want me to?
Sure, I think that's a good idea. Mr. Brooks, did you hear the state's concern as voiced by Attorney Opper just now?
I think you were pretty clear in what you advised me of. I think you made it very clear that it would be challenging, but not impossible. That was your exact words, verbatim. So what needs to be made abundantly clear when you've already done it?
Thank you, Mr. Brooks. One of the challenges of being judge is I can't give advisory opinions, right? I can't give advice, but in the context of waiving your right to an attorney, I think it's important that you understand exactly what Attorney Opper has just said, and that is this form is generally used in the pretrial context, not at the 11th hour on the verge of a trial starting. You are correct. It's not impossible. It's incredibly challenging. We told you a couple of the cases that I would need to consider. But what I would further tell you and advise you is that the right to an attorney is not absolute, and that's from the case law. Once waived, the Sixth Amendment rights of counsel is no longer absolute. And I'm looking at the Wisconsin case of State versus Rhodes, citing to United States versus Salina, and other cases from various circuits. That was a Seventh Circuit case, but Menfield versus Borg, Brown versus Wainwright, Merchant, United States v. West. Those are all cases that are cited by.
Now, you make a good point. He's not protected by the mask anymore. All right. No longer does he have his mask on. Very dangerous times right now for Darrell Brooks. He's put himself in the line of fire. I have a good feeling he might get COVID.
We could only hope.
This will come up in trial. Trust me, this will come up in trial where he claims to have COVID. Oh, but the judge gives him a rapid test and forces him to take a rapid test. And oh, you would be so surprised at the outcomes that she reads online, which he are on stream, where, he's going to claim that it violated HIPAA rules because he's a hippo. Oh, no, HIPAA. No, it's not HIPAA. By the way, hit that like, subscribe if you're not subscribed, hit that like, hit the subscribe, and also if you're not a member, remember, Just J Hip on Tuesday mornings. Unlike the flea bags, Just J Hip provides you a wonderful members only stream every single Tuesday from 8 to 10. So if you want to go a little further and become a member or give a little bit of pear tree money, you're more than welcome to, but it's not required. but you can. Thank you very much. But thank you just for being here. In the chat is just killing it. He's shackled, right? Yeah, he's shackled. Oh, he's got the shock. He's got the shock devices on. The shock devices. No, he does not. This is a lie by Darrell Brooks. Okay, Darrell Brooks.
Roads. And I referenced
I always call it hip.
state versus Lomax. There's also state versus Lovetto. And these are some of the considerations that I would need to consider if it were raised. And that includes practical concerns of managing its docket. That's my concern. Impact that a request may have on its general responsibility for the prudent administration of justice, the timeliness of the request for substitution of counsel. All of these cases are substitution of counsel cases, but the case law makes clear that when a pro se person seeks to now,
Okay.
however you want to call it, sir, in pro per person wants to
Torture God.
request
He's
an
chilly.
attorney, I treat that
He's
as
chilly
a
all
request for
the time.
substitution of counsel because you're acting as your own attorney. I think you understand that because we've discussed it, you've acknowledged it, but did you hear all of the advisements just now?
I heard the advice.
Any questions for me about that?
No.
All right, Attorney Alper, the next.
Also, I think you have made it abundantly clear, but you touched on the idea of co-counsel or hybrid counsel that obviously once he's allowed to self-represent, there will literally be no one sitting next to him, not as if he can ask some questions and another attorney sitting next to him can ask some questions, or they can share responsibilities or duties.
Torture.
Thank you. Mr. Brooks, did you hear what the state just said just now?
I heard it, and again, I think, like was just stated, you were abundantly clear on that issue as well.
We talked some yesterday about some of the challenges. You would agree with that?
As far as it
Representing yourself. And I'll be a little more specific. Yesterday, I went through the experience of not only your own attorneys, but the experience and the resources available to the state. Do you remember that?
I do.
I may not have said it this way, but one of the things the state will be able to do is there are 3 attorneys seated at that table. They can divide and conquer the work between them. Did you hear what I said?
Yes, ma'am.
You're fully informed about that, correct? And I'm going to I know you don't like this word, but you understand you're going to be sitting at that table by yourself, right?
I'm not alone, I don't think.
Look at
There will
how
be no
confident
attorney seated next to you,
I know what
correct?
you mean. I know what you mean.
All right. You will have the sole responsibility to cross-examine witnesses, to present evidence, to make arguments to the court, etc. Did you hear me say that?
Yes, ma'am.
And you're informed of all of that.
I am informed.
Any questions regarding that?
Not at all.
All right, Attorney Alper, your next point.
Thank you. On the second page of the form, you did touch on him under the section that reads on the form. I understand that if I represent myself on the 5th bullet, he wrote in there, please elaborate first. I believe you did elaborate on that and further told him that you're not allowed to provide legal advice to him, but I didn't know if there was a specific question that Mr. Brooks had that perhaps the court could address, perhaps not, if it hinges on legal advice. But it was a little bit ambiguous.
Can we time out Kelvin for the next 30 minutes? Please time out Kelvin. And if we could
Hey,
time out
Kelvin.
Kelvin for bothering Mr. Hip. If we could just time out Kelvin, please, for bothering just J Hip. I'm doing very serious court trial here. It's very serious. Happening as we speak, all right? In fact, I just canceled People Watch this evening. I just canceled People Watch because of Kelvin bothering just J Hip. Hi, David Green. How are you? Kelvin, you just caused Just J Hip to cancel People Watch.
Ambiguous what he wrote there.
Fair enough, sir. You obviously wrote some things on this form. Do you have any questions for the court at this time regarding this form?
Just
I
saying.
think you touched on it a little bit on what the question would have been, and that was basically just the stressing that I did of the pro se thing, because essentially, from my understanding, is that pro se, in a sense, because I would be basically like I'm a licensed attorney, so that would kind of limit what I'm
I'll
able to
give
do
you a
versus
Fleacap
being pro
when we finish this portion.
You touched on it a little bit.
Not a
man.
ton left.
Gave me a little
Sir,
bit
I'll
more.
tell you, it doesn't matter what you refer to yourself as, whether it's pro se, pro per, in pria, persona, you will be acting as your own attorney. And I believe you fully understand that. I want to go back to the box that you did not check, though. Given everything that we've discussed here today,
Shut up, Calvin.
do you have any questions regarding the section regarding what an attorney would do on your behalf? I don't mean you acting as an attorney, but a licensed attorney in the state of Wisconsin assigned to represent you.
Yeah, you touched on it. I think it came up like right when I had voiced that, and you kind of clarified it.
No Fleacap.
Understanding that this section refers to a licensed attorney in the state of Wisconsin, would you be willing to check this box now? That you have read this section and that you are informed of the above.
Yeah, I'll check.
You have the original. I'm going to ask that if you're willing to do that, that you do that, initial it, and date it.
Quick question on that. What is the significance of the initials and date? As it pertains to
For me,
not having to do that for the I think you know what I'm saying.
for me, the form that I have was signed yesterday, the 27th. Today's the 28th. It's an indication anyone reviewing it later would know that that was added at a different date.
Okay.
It preserves the record from my perspective.
Yes.
All right.
Yes, Dwayne, you can. I love our chat. I love our chat.
Then quick. The record should now reflect I do have the original, which actually is a little bit easier to read than the scanned version.
I'll lose it.
And Mr. Brooks did check the box that was originally left unchecked. There appears to be 3 initials and then today's date. Thank you. Can you offer your next point?
Last point that relates to the form, and it goes hand in hand with what just occurred. At the bottom of the form, it states in all bold letters, this form shall not be modified. It may be supplemented with additional material. I think that's standard printing on the form, but I just want Mr. Brooks to be aware that obviously you are accepting the form as modified by him at his request, so that there's no question later that you accepted the form contrary to the printing on the form that says it should not be modified.
Thank you for bringing that up as well. I certainly understand that. Mr. Brooks, you would agree any of the changes that were made by you and not this court.
Yeah, I mean, I feel like we've covered everything dealing with that form. I don't understand the relevancy of stressing the form that we just spent so much time going over. I think you were more than clear in your advisements of exactly what the form meant, and you were pretty clear.
Thank you. Is that it, Attorney Opper?
That's it to the form. I would request an opportunity to be heard on the motion prior to ruling, or if you're going to defer ruling.
No, I am going to rule. I will certainly give you an opportunity to make any statements you want before I.
Did somebody really time him out?
Yeah.
The only outstanding issue, Your Honor, we have not yet spoken of it today on the record, was the letter that was filed by the defendant's mother.
Do you wait? I think timed him out for 10 seconds. Calvin was going to possibly cause a lack of a Fleacap because of Calvin. Gang, gang.
Oh, Calvin.
Just
I didn't do it. I didn't do it, Calvin. Don't come for me.
He's back. It was just 10 seconds.
I know.
We have the funnest chat over here. I tell you, I know this might seem a little dry and boring right now, but trust me, these attorneys are going to get up and run for the hill in about 2 seconds. Late, good morning, Muppet Angela. How are you? Mama Bear Leah. Yeah, she was the first person ever timed out by just straight up.
That's because Jay doesn't know how to do any mod activities on purpose.
I love all of you. This chat is the best. That's why I wake up in the morning and I do this for fun and excitement. And, well, I liked this try.
I believe it came in late yesterday afternoon or first thing this morning, in which she has indicated she thinks Mr. Brooks is not competent to be making these decisions. I just wanted the record to reflect that we reviewed the history of offenses for Mr. Brooks in the state of Wisconsin. We know he has a record outside the state of Wisconsin, but we have not been able to develop that. First, the record should reflect that he is experienced in the criminal justice system. He has been charged and convicted and sentenced for prior felony offenses. He's been through the court system on at least 10 prior occasions, or 10 prior cases, I should say, in the state of Wisconsin. The majority coming from Milwaukee County, one from Wood County, one from Manitowoc County. We could not find on any occasion, searching court records available online, a situation where Mr. Brooks had competency was ever raised, or he had claimed himself to be incompetent, or counsel or the court had ordered an evaluation for competency. It's never been an issue in any of his 10 prior cases. We're also aware of the NGI evaluations that were performed in this case. It's certainly a different issue, competency versus insanity, but they were all licensed professionals, psychologists and psychiatrists, in my professional opinion, would have alerted the court if in the course of their NGI evaluation, they thought there was concern as to the competency of Mr. Brooks. That did not occur as well. Lastly, I would note, and Attorney Perry touched on this at the beginning, he started to touch on it, that Attorneys Perry and Keyes apparently have never felt that competency was an issue or needed to be addressed by this court. It has not been raised by them. Court record here is clear. I've been at every court appearance. I have never had any concerns of Mr. Brooks' competency. He appears to me to be intelligent. He appears to fully understand what's going on in these court proceedings. He has the ability to communicate efficiently and effectively with the court. He has responded to the court. Some of his answers seem to fall more in line with his declaration yesterday that he's a sovereign citizen, but he has always participated in the court proceedings and never appeared to be in such a manner that he was not able to understand or assist in the proceedings. So I just wanted to make that record as well. And I think that's it for my comments, Your Honor. Thank you for the opportunity.
Thank you. Mr. Brooks, anything you want to add to the record at this point regarding the request?
Yeah, yes, I do. I'm trying to grasp the relevancy of that whole issue, especially the part that was just said about me participating in everything, seeming to know everything that's going on in the proceedings up until this point. It's kind of misleading a little bit, I think, by the state, because I recall it being an issue when the whole misunderstanding happened in court back in last month. I think it was the 26th, if I'm correct. It was a whole issue about me being, quote unquote, asleep in court. So I think that's kind of misleading to raise all the competency things. I've been intelligent and all these things, and then raise the same things. That's kind of like a clash. I don't understand that. I don't understand the relevancy of it. I don't understand the relevancy of the NGI plea being referenced to when that plea was essentially withdrawn. I don't see the relevancy of prior cases. With this case in front of you now, I don't see the relevancy. I think you're more than capable of making the right determination based by what you have in front of you now.
Thank you. Before this court gives a final decision, I want to go through a little bit of the procedural history of this case, not long, and then some of the case law, because it is important as this court decides this very important issue. So as everyone, I think, is aware, the Waukesha parade occurred on November 21 of 2022. I believe it was 2 days later, on November 23, that charges were filed.
Year was 21.
Did I say 2022? Thank you. We're in 2022. Thank you. 2021 is the incident. This case is 21 CF 1848. There's been a significant amount of litigation in this case already. There was a contested preliminary hearing. Then the first appearance occurred before Branch 2 on March 11th of 2022, about 202 days ago. It was on that date that this court set aside the month of October to hold the trial. The first trial order was issued. Many of the dates were discussed, but the trial order wasn't issued until April 11th of 2022. That is when it was formalized. Going back to the March 11th date, though, a decision was used on that date to utilize a jury questionnaire, meaning a case-specific jury questionnaire. There were related deadlines that were discussed. On March 29th, we held a hearing to discuss the questions and finalize the questionnaire.
Let me point out a few things. This actually occurred in November of November, I can't remember. All right, of 2021. All right, and then things were set forth in 2022 to proceed with the trial. Now, with a trial like this, they take a long time. Now, Darrell Brooks is going to claim that his trial did not happen, within the appropriate amount of time. He was not given a speedy trial. He had lawyers at that time who requested a postponement. They requested more time. All right. This was not, him being denied a speedy trial. Should he wanted one, he could have had one, and he could have gotten all of his life sentences very, very quickly. But of course he didn't want that. But he's going to claim that is the reason why He wasn't prepared because it was a speedy trial. All right. He said at one time, he says, I didn't get my speedy trial. Then when he represents himself, he says, well, this was a speedy trial. I didn't have time to prepare. I fired my lawyers on Wednesday, and then we went to trial on Monday. It was too fast. So this guy wants it every single way that he can have it. That's what he wants. Oh, Darrell.
Mm-hmm.
But I love you. No, I don't.
At that point, the court was alerted to the defense potentially raising a motion to adjourn. I set a motion date. The court heard and denied a motion to adjourn the trial. From my perspective, that motion was primarily related to potential concerns of the defense regarding the ability to be prepared. We discussed additional deadlines. From my perspective, this is a case where the state has worked diligently to quickly turn over all discovery material. From my understanding, again, not having reviewed all of it, that's not my function at this point, though it was very voluminous. It included paper discovery, electronic discovery, but the court set appropriate deadlines.
Lawyers
exchange a witness list. Of course, Mr. Brooks initially entered a special plea on June 20th of 2022, where the plea of not guilty by reason of mental disease or defect was entered. That resulted in a certain series of events occurring. Just prior to that, I also, I think I already referenced this, finalized the first trial order April 11th. Ultimately, I amended that on July 12th of 2022 to encompass some of the issues related to the NGI. Then this court held 2 days worth of hearings on August 25 and 26 to address a variety of motions. I know you may not understand the relevance, sir, but it is important just to note that on August 26th, there was an outburst by Mr. Brooks. It resulted in the court taking an early recess, and he was temporarily removed from the courtroom. When he came back, we took a break, I should say, and then there was the outburst that resulted in the removal, but he came back. He was there, I think, for about 2 hours before he requested to leave the proceeding. But I believe the record would fully demonstrate that when I questioned him regarding his desire to leave, he demonstrated an understanding of what he was doing. He answered my questions at that time. He understood, from my perspective, that he was leaving the proceeding. Then the court moved on to September 9th. That was the jury status. On that particular date, the court essentially adjourned the proceedings. Mr. Brooks complained of a tooth abscess. I was able to fit it in with my schedule, and so the jury status was adjourned until.
What show is that from? Bob Newhart? Was that the Newhart show?
No.
I'm Darrell. This is my brother Darrell. My other brother Darrell. I think it was Bob Newhart show.
Was it?
I think so. In chat, you're gonna have to let me know. I think it was Newhart.
Happy said yeah. I mean, I definitely remember it, but I just don't remember what show it came from.
Yeah, I'm Darrell. This is my brother Darrell. This is my other brother Darrell. Yes, says Kirsty Witch. Yep, I'm familiar with my old Nick at Night TV shows, I guess. Bob Newhart. You know what I used to like? I used to like the Dick Van Dyke Show. You ever watch the Dick Van Dyke Show?
Yeah.
Yo,
I used to watch that.
And
the Honeymooners. I loved the Honeymooners when I was a kid.
My family watched the Dick Van Dyke Show all the time. I think somewhere in my house, I might have their entire collection on DVD or something. I don't know. But it was so wonderful, the Dick Van Dyke Show, because if you look at all sitcoms from then to now, a lot of the sitcoms are all based on the Dick Van Dyke Show. They all run around the same premises. They have the same storylines, very similar is what I'm trying to point at. Is the Dick Van Dyke Show was very instrumental in a lot of TV drama going forward when it comes to couples, relationships, families. But yes, I love the Dick Van Dyke Show. It was wonderful. And there we go. But no, I don't watch sitcoms anymore. I don't have time for it. Because I have my own sitcom that I'm running right here.
My favorite sitcom as a kid, like from the 80s and 90s, was Roseanne.
Roseanne. Yeah, I liked Roseanne a lot too. You know what I never really watched? I watched the Beavis and Butthead a little bit.
Yeah.
But The Simpsons. I only watched The Simpsons very briefly. I was not huge into The Simpsons. Wasn't my deal. But I did grab a few others. And there were some shows I really loved, like 24 when I was out with Kiefer Sutherland. I love 24. And that's the same thing, like with the anti-house ecosystem. I don't want the anti-house ecosystem just disappear. Like after season 8, they're gone. I'm like, no. Stick around for a little bit. Keep things together. We need to keep united because, quite frankly, I need you for at least another 3 or 4 more seasons because I enjoy your stupid. All right, before you all, go to prison or wherever you end up going. I want to keep you around a little bit. Don't pull a 24 and just disappear. Let's finish this up because the lawyers are getting ready to walk out of the room here.
September 19th, the jury status was held. We covered a number of issues at that time. The state raised the need or the desire to have the court rule on some additional issues. We set some deadlines for that. At no time prior to the jury status was this court ever advised of Mr. Brooks' desire to represent himself. And then it was on the 21st of September that the motion was filed. Of course, the court set the hearing initially for yesterday. Court started the hearing, essentially stopped the hearing, provided Mr. Brooks with a number of documents. Those documents are noted in the record, but he was provided with documents 42, 82, 230, 232, 233, 234, 235, 236, 237. There was a circuit court record selected, also provided to him. That's of note because that selected circuit court record also lists all of the charges. The documents that I provided to Mr. Brooks, which I believe the record also bears out, he had previously included the second amended criminal complaint and the information. The documentation also included CR 226.
7 days.
In preparation for the hearing yesterday and today, the court also did not only go through the procedural, look through the court record. I certainly read a number of cases, including in Wisconsin, State versus Klessig. I've already referenced the Rhodes decision. I reviewed that. I reviewed the federal decision of Amani versus Pollard. I reviewed Pickens versus State, Indiana versus Edwards. I reviewed State versus Amani, which was the predecessor to the federal decision in Amani versus Pollard. There's other cases as well, but those are essentially the critical cases of court's determination. I also reviewed all of the NGI evaluations as well. And my purpose in doing that, a couple of different reasons. Number one, those evaluations were done by licensed professionals, all of which I believe have a PhD after their name. And as part of those evaluations, which were done in July and August of 2022, each examiner did a mental status exam. And in each of the reports, it's noted, frankly, no concerns over Mr. Brooks's mental status. One of the criteria this court needs to look at is whether there is a mental illness that would essentially impair Mr. Brooks's ability to understand what's going on. That is because the federal cases talk about where there is a narrow class of cases in which a defendant may not be competent to represent himself at trial. And that situation typically would be a severe mental illness to the point where they are not competent to stand trial or to conduct trial, themselves. In this particular case, I have absolutely no indication that Mr. Brooks suffers from a mental illness or mental impairment. I know his mother wrote a letter. I did review it as informational only. She does not use the word, I don't believe she uses the word competent or competency, but she references her concern regarding her son being unstable and her opinion that he is making the wrong decision. I'll get to the case law on that momentarily, but this is where the NGI evaluations are of importance to the court. As I indicated, there are 4 evaluations that are on file. 3 of the 4 doctors all diagnosed Mr. Brooks with a personality disorder. I'm going to quote at length from.
It's my turn. Let me go through this.
Well, there you go. Where we had there. All right, the judge made her decision. The video cut off there, and that was by the trial cut off there. but the video cut off. We're going to pick things up and continue, of course. But Just J-Hip promised you a Fleacap. Of course, that's what Just J-Hip does. I promised you a Fleacap, and then I'm jumping right back into Darrell Brooks. But I promised you all a Fleacap, didn't I? I think I said that, right, Ketchup?
You did.
I did, and I'm a man of my word, but give me a second. I have to pull a few things up. I have to get a few things ready. Hang on here. I'm pulling up some stuff. Just your hip is pulling up some stuff. It's just your hip. Some stuff. Oh, yeah. You're gonna have to sit tight with just your hip. Okay.
Calvin said, I thought I canceled it.
Well, not yet, but you're about to.
That's hilarious.
Hang on. I gotta wait for this to load. I'm trying to get to the point where the lawyers actually exit stage right or exit stage left for them, but exit stage right to us. But I'm having problems with it loading. We'll let that go for a sec. But since you all have stuck around, since you all have hit the like button, since you all have decided to join Just Your Hip and Ketchup this morning, I will give you a Fleacap. And here we go. Yeah, wait, hang on. I need my material. Where's my stuff? Let's see. Oh, there it is. Okay, got that. Hello, everyone. What's everyone doing tonight? I'm here. I got Stacy here. We got everyone's here. We're gonna. Tammy's here. Slobby's gonna be joining us. Should be a good time. Yeah, you look at all these lies. All these lies that these people are putting out. It's nothing but lies. All right? Tug never talked to Elemental B. I haven't watched the show. I never watched the show. I don't do it. I don't watch the show. I get screenshots. I don't watch the show. It's not what I do. All right? So, but I get screenshots, but clearly Elemental B has never talked to Tug. What they're doing is they're taking clips from other clips of other clips and making it sound like they are doing the clips. These aren't their clips. That's what I know. But these people are disgusting. I would so say that they are so disgusting, the things that they are doing on their side, I would say that as well, even up here in Canada, I would just say these people are really disgusting, and I do like to just agree with everything that Fleabag says. Well, I appreciate you agreeing with everything Fleabag says. Now, at the same time, I'm so close, and you got the face and Hey! I got a chicken skin. It's caught in my gullet. I got a little bit of chicken skin caught in my gullet. No, I don't eat chicken skin. Never mind. That's a lie. See, one more lie. The germ's caught up in. And you can see clearly he's stalking a family. That's what he's doing. He's stalking a family, and that's what I care about. I care about protecting a family that is being stalked by this terrible Jeremy Hales. And he's just a small portion of this. Because really, it's this Megan Fox. All right? This wannabe journalist, this waitress, wannabe journalist. All right? That's what I'm saying. A wannabe journalist. Hey, look, Slobby's here. Slobby's here. Hey, what's going on? Hello, Chicky Chee. Hello, Tricky Chee. Hey, I can't hear anything. Can you hear now? I can't hear anything. Can you hear now? I can't hear anything. Am I on? Can you hear now? I can't hear anything. I'm trying. Hold on. I can see chat now. Can you hear now? Oh, yep. Now I can hear. Okay. Everything. Yep. No, these people are sick. What they did. They came after my family. They came after Piper with the blue tape, the painter's tape. It's terrible. You don't see me. I used to live with Cece. Yes, say. I used to live with Cece. We had a 20,000 square foot house. 20,000 square foot house. They don't even make them that big anymore, do they? Not anymore. They don't make them that big anymore. But I used to live with Cece. And Cece used to always tell me, to make sure you never attack anybody with blue tape. And I've lived my life by that. I never attack anyone with blue tape. And Jeremy House clearly did that to me. All right, and to my family, attacked my wife, all of my gators, and my daughter, and everybody. And it's just crazy. Well, these people are sick. And they want to make a memorial for a memorial that never was. Oh my God. My memorial is private. It'll happen when it happens. And it'll never be seen by anybody because that's what the family wants. If these people think they're going to see my memorial, all right, that they spent $4,000 on, it's never going to happen. All right, because it's private. And that's to protect the family. And that's why I do what I do. It's about the family and the kids. And protecting the kids, the family. By the way, it's also a two for Thursday. It's a 2 for Thursday. So if you want to give any money, it is 2 for Thursday for Christmas to give money to me, and then I will give that over to the family, so for Christmas presents, stuff like that. But the family is what matters at this point. I'm sad. I was really trying to protect the kid. A kid. So I was trying to do one child, and she's still a part of this. She's getting presents too. Everyone's getting presents too. Harley's getting presents. The 15 other people are getting presents. We got deodorant. Ah! Ah! We got deodorant. Shower heads. By the way, don't forget, if you do want to donate over to the Holly Jolly Christmas, do donate. It is 2 for Thursday. So any dollars that come in, it will be a twofer all set up because Strictly is doing a twofer. And then I'm going to go back to crying for just a little bit. Oh, it's terrible what they're doing about. Wait, hang on. Looks like Paint Chips wants to get in here. Paint Chips, I heard you had a back and forth with Megan Fox. Megan. Let's see. Oh, hang on. Oh, yeah, I think he wants to get in on this. He definitely wants to get in on this. Oh, yeah, even from Canada, he definitely wants to get in on this. I would say. Oh, yeah, I'm here now. Yeah, I'm just telling you, to be quite honest with you, I'm pegging everybody right now. You want to look at this. You want to look, Megan, she's talking. She's a disgusting individual. Disgusting. She's disgusting as all hell. I don't like her. She's so disgusting and so terrible. I wouldn't touch her with a 10-foot pole, but apparently I'm going to say this right now. That I have pegged her. I've pegged her so many times. You want to talk about revenge porn? Let's talk about a little bit of revenge porn. All right, I'll make things very clear. In order to have revenge porn, you would have had to have a relationship with this person. You would have had to have an actual relationship with this person. I'd never relationship with this person. Oh, but I guess I had. So when I was pegging Megan Fox and I was pegging Jeremy Hales and I was pegging Jay Hip and I was pegging Tug and I was pegging Rogue Mama, Trash Panda, I was pegging all of these people, just pegging them over and over and over again. And that's why, I made a post, to make sure that they all knew that they were all properly pegged by me. That's why I released my revenge porn. They want to call it revenge porn. It's not revenge porn. It doesn't really matter because the thing is, they're all going to go to court, and then you look at Pocket Rocket Chocolate Hocket, and Pocket Rocket Chocolate Hocket, and then Itty Bitty Titty Hitty, and, and they all hooked up outside of, and then the divorce and the stuff, and then left the kids on alert. It was terrible what they did to this child, to these children, and he was a terrible individual. And then Itty Bitty Titty Hitty, she wanted to get on in the game, and now next thing you know, she's all upset just because people are talking about her, and people should be talking about her according to her, but she's a public figure, in my opinion. So clearly, that's why I had to peg everybody. I was pegging them and pegging them and pegging her. That Megan Fox. It was, and here's the thing, this is satire and parody, folks. I just want to make sure that's clear. This is a satire and parody, and nothing we're saying is true. Well, it's true. I'm going to tell you right now that it's true. Everything I'm saying is true. Because I was in the back seat of the car with Jeremy and Megan Fox, and I was pegging them, and then Tug entered the car, and then J-Hip and Trash Panda entered the car, and I was pegging all of them in the back of the car because that's how it works. When you do revenge porn, you have to have had a prior relationship. So therefore, clearly, I had a prior relationship because I was pegging Jeremy Hales and Megan Fox. This is obvious as it seems, and this can be followed up if you look at the court case. This court case is the Florida statute, SC 56701. If you look at that one, all right, you can see clearly that it's allowed. It is allowed to put out revenge porn as long as you've had a prior relationship. And by prior relationship, I would mean just saying that I have pegged all of these people. And I pegged them and pegged them and pegged them and pegged them. Well, that's great, Paint Chips. Thank you for popping over and sharing that portion of defamation. That's delightful. Well, what do you think's going to happen going forward with the cases based on what you... I just want to say this. They came after me with blue tape, and it was blue painter's tape. Does anyone not even understand that? This was blue painter's tape, and they attacked my family. We're talking Piper, my wife, and Piper, and my wife, and we were all attacked with painter's tape. I would never attack anyone with painter's tape. I've never done that in my life. Even when I go and say I track down an alligator, I put tape around their mouths, but never painter's tape. That would be too traumatic. So I never do that. Well, that's one of the things I would tell you. These people are relentless. They will come at you with painter's tape, and it's very scary, but not for me, because I used to be a lawyer. I know a lot of stuff about the law, but that's the thing. You know a lot about the law. And I'm not a lawyer. Maybe I'm not putting this correctly here, all right? But, Bruce wasn't in court the other day, all right? But he didn't have to be. He wasn't there to defend himself. So whatever happened in court doesn't matter because he wasn't there to defend himself. So there's that. He wasn't there to defend himself. All right, same with the element of P. They weren't there. They weren't supposed to be there. All right, as far as I know, because of the stay. And they weren't supposed to be there. And now a judge made a decision. Now, it's not a ruling. All right, the judge kind of made a decision based on sorry, air. There's a lot of air in my. I get the air stuck in my butt. But no, he wasn't there to defend himself. So therefore, nothing that happened in court yesterday really matters, because that you have to be in court to defend yourself, or it doesn't count. That's that's one thing. That's one thing. I mean, Bruce wasn't even informed. He wasn't aware. He didn't even know he'd be there. That's one thing. That's one thing. And the court's going to look at that. They're going to decide and figure out how it's going to go. But I'm pretty sure if he's going to get a first shake, he's going to have to be there in court for him to ever. And not only that, but this isn't even gone before the Supreme Court yet. I mean, it has to go before the Supreme Court before it could happen. I'm not a lawyer. I might not be saying this correctly, but I'm just saying he wasn't there. You got to be there. You got to be there. And quite frankly, I mean, he wasn't even pegged. You got a certain amount of people who've already been pegged. You got Megan Fox, you got Jeremy Hales, you got Tug, you got JF, you got Trash Band. They've all been pegged. All right, but as far as I know, Bruce has not been pegged yet. So Bruce is not going to have to be in court just yet. So he's not aware of anything that's going on. Not very clear what's going on. And that's why I would say what I'm going to say, But yeah, I mean, that's just case law. You can look it up. I mean, you got statutes, Florida statute, CS 56109-625. And that'll clearly point out that you have to be in court in order to be sanctioned or to get in trouble, or you have to know about your court date. And it shouldn't have been in person anyway. It should have been via Zoom. I don't believe they were given a Zoom link. Very clear. There's statute on this. That's a statute, Florida statute 6819603. Very clear that you have to be given. A Zoom link if you're out of state. So that's what happens over there. I just want to point that out. Very, 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 very clear. But no, Bruce was never even pegged, but all these other people have been pegged. And we're going to see how that goes. Well, we're going to see it. I was just going to say, shut up, Kyle. Shut up, Chuck E. Cheese. Shut up, titty mouthwash. Shut up, smutty smut face. Shut up. Are you done? We were doing a show here. Are you done? I guess so. Yeah, you speak when spoken to, all right? You speak when spoken to. I was just trying to agree with everything you say. Oh, yeah, I was also in Canada. I was just trying, to agree with everything you say, because that's what I do. Just supporting a friend in Canada. I'm just supporting a friend, living in my quelling. Well, yeah, you gotta live in a quelling, and, we're trying to do right for a family. A family, and that's what we care about, is a family. Ketchup, it was a tough show to follow, actually. Different directions from this one, Ketchup.
You forgot the.
Oh, yeah, I forgot. Yeah. I'll add that in the next one where Leatherface comes in from 4 blocks away. It's like, everyone's a twat. They're twats. Leatherface pops in from 4 blocks away to call everyone a twat. Yeah, and thanks, Leatherface, for popping in on this one. It's a terrible show. It really is just a terrible show. But thank you, Mama Bear Leah. Jay, have you noticed Megan is starting to do your little hum when she's looking for something? Is she? Is Megan stealing my shtick, Mama Bear Leah? Megan stealing my shtick. Oh, that's intellectual property theft right there. Just say hello. Hello, intellectual property theft right there. Just saying. It's intellectual property. Megan said Loofamobile, or no, George said Loofamobile, and it's intellectual property theft. The dummies actually said this on their show. Thank you, Mama Verlia. I'm here. Start the stream over. Really, Paramount? You want to start with Darrell Brooks being his own lawyer again? Or we can move into trial day one. Intellectual, kind of fast and loose with words, Jay. Yeah, I know. This is terrible. I laugh my way through every single one of their shows. I think they're delightful for me because I get to Fleacap them. For you, probably painful, probably not so fun. But me, I watch their show and I'm like, I do that the entire time. If you want to go watch a Fleabag show, go watch a Fleabag show. I'm not telling you not to. I'm saying I'll do their show better in 15 minutes than they do in 4.5 hours. All right, trust me on this one. I might miss a few things, but I'll pick them up on the next one. I promise you. But there you go. Now I was thinking though, Ketchup. Can we maybe go into day one of trial? Can we start that? Just a little bit of it?
Yeah, I'm ready. Let's do it.
Are people okay with that? Or are you guys okay with that? Are you guys saying just J-Hip needs to get off? Not get off. I mean, but get off the stream. No.
Phrasing.
It's not. This is not. Are you saying just J-Hip needs to go away because you have other things to do? Otherwise, can we start day one of trial for at least another 1 hour and 17 minutes because I have until noon? Are we okay with that? We want more, says Mr. Landfill. Maria says, yes, I'm okay. I'm trying to save my phone. If I watch Flea, I may break my phone. Don't watch Flea. I got that for you. I got this covered for you. Bill money. Jay will need commissary money in jail. I do need some commissary money. Thank you very much, Faves. Yes. All right, let's get over. Let's do a little day one. Let me set it up here. I'm gonna make our settings playback speed. I will move that to 1.5 times speed. All right, got that set up. And the message. Just Jep is awesome. Just Jep is awesome.
Yeah, add the part too where she was trying to say that Jeremy said he was going to sue his son because that was garbage. Never happened.
I'm not doing that.
I was like, where did that come from?
Well, and then of course, there was so much in it. I could not do the whole damn thing. I mean, there was 4.5 hours. Slofer was in there. They were talking about Slofer. He was being a jackass. And yeah, there was a whole thing. There was too much almost last night. Here we go. Let's look at Darrell.
There was a lot of scotch tape noises.
Yeah, because we were packing up our Christmas presents, because it was a 2 for Thursday or a 2. God, Jesus shit. Hey, we're here at trial. Darrell Brooks says all of his bark.
Oh, good. He's got the mask on again.
He's got the mask on. And don't forget.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks,
He's
case number
gonna
21
build
CF
a box fort
1848.
on
Let
day
the chair
10.
reflect that the state appears this morning
I
by
can't wait.
District Attorney Sue Weber, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Wichow, and the defendant, Darrell Brooks, appears in person in custody. I'd also like the record to reflect that he is appearing in jail attire today. He's also wearing a mask.
I'm just saying, Your Honor, I'm not identified by the name and would like the opportunity to state that I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value and return for
special
value all
appearance,
charging
right?
instruments in this matter and make my exemption
He's
available
Super
for
Dave.
discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today.
He's in
I'm asking you to
jail.
respectfully
In
not interrupt me.
jail,
That's the second time, so I
serving
can go
for
through the list of
special appearance too.
You just interrupted me within the first 30 seconds of starting this trial. But he's here on special appearance. So apparently Super Dave is going to be representing him, or I don't know. He has a J haircut, says Fred Psycho. Rude! You people are terrible to just J him. You're supposed to be nice. By the way, do hit that like, do hit that subscribe if you haven't. I appreciate it. Also, any sort of breath or a person are always welcome. Thank you very much.
And I have to say, Jay has more of a George Jefferson hairline, not a Darrell Brooks hairline.
And we
Just saying.
We do a people watch tonight. People watch tonight. Here we go. Back to the dummy.
things that I need to get through this
I
morning.
just wanted to state it for the record. that
Mr.
I'm
Brooks,
identified by
it
the
wasn't
name
the
that you brought
proper
me by,
time
that's
to
all.
do that. That's now the third interruption. So,
With all due respect, Your Honor, every
Mr.
time
Brooks,
we,
by
every
saying
time
all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done.
But it is
I
my
have a
right
number
to-
of documents
it is
that I
my
need
right
to discuss
it
this
is my
morning.
right to-
Mr. Brooks, you do not have a right to interrupt the court.
No, it
I will
was-
remind
that
you
was not
once
my
again
intention.
of the Supreme Court rule. It's on a yellow laminated, double-sided piece of paper that is before you. I
do not
checked, I
recognize
verified,
that.
it
I
is.
accept it in return
Mr.
for
Brooks,
value,
that's
Your
yet
Honor.
another interruption. Let me get
She's
through this,
marking him
I just
down.
want-
She's
for the
You
making
will
record,
have an opportunity when I give you an
I want-
opportunity. No one else
stated-
is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
Mr. Brooks, I am going to keep going. You are warned. You need to follow the.
I have to make something clear as we get into the actual trial. Okay. She cannot, well, she can, but she cannot put him in contempt of court. All right. Let me make something clear. Say she puts him in contempt of court for 30 days. The trial gets postponed. She can't do it. Okay. So I saw a comment that said something about contempt of court. She can't do it. And she knows this very well. She has to do everything she can do within her legal boundaries not to find him in contempt of court. So that's why she has to remove him to the other courtroom, things like that. She can't put him in contempt of court. And she knows this because it just extends the trial. Also, you have to remember, they ran through 1,600 jurors to get a fair jury in this deal. Okay. They went through a lot of freaking efforts just to do this. Okay. So this is why he wants to be found in contempt of court. He will state this many times. He'll say, "Oh, you're holding me in contempt again." And she's like, "No, you're just going to the other courtroom." Okay. But she can't hold him in contempt of court. I mean, she can, but she understands the risk. Okay. I just want to throw that out there. If anyone's wondering why she did or did not do that, there you go. All right, back to our show.
Standards of courtesy and decorum for the courts of Wisconsin. Chapter 62, that's another interruption.
I intend to follow the
This court comes with a history of Mr. Brooks interrupting now. This is day 4, and every day Mr. Brooks has interrupted. It has resulted in Mr. Brooks being placed in a neighboring courtroom so that this court can efficiently, effectively, and with dignity preside over this case here today. I am well aware, that's another interruption. I'm well aware, stop
which I have the
talking.
right to do.
I'm well aware, Mr. Brooks, that you
Now, I do want to understand. She says this is day 4. Okay, we are on day 1. All right, we're talking about day 1 of trial. When we talk about day 4, we have to remember that there was a few days leading up to him dismissing his lawyers. Okay, so there were a few days leading up to that. Okay, now we're in day 1 of trial. I know that she says day 4, but this is day 1 of trial. So let's get that going. Okay, I just want to make that clear.
You object to the name that has identified on the information and all documents in this case. Your objection is noted. It does not need to be repeated. I will make a record right now. The court notes a continuing objection by Mr. Brooks of his name and that he objects to being here. I know he's filed a number of documents previously related to that. Those documents are of record. There's another document that's filed, at least 2 more interruptions just now. I believe I'm up to 8. Mr. Brooks, you're advised that continued interruptions will result in you forfeiting your right to be present in this courtroom, where you'll be taken to the courtroom next door to appear by video and audio means to participate.
From the courtroom,
That's another interruption.
You haven't shown me any lawful case law that I can be removed from the court proceedings in a trial and forced under coercion and duress.
Coercion
that I needed, that I've tried to express that I have.
Mr. Brooks, there's a proper manner in which you raise objections. You have not.
Coercion? What is coercion? Oh no! Coercion? I bet you. Do you think it's going to be a tacket agreement? Trust me, we're going to get to all of the tacket agreements that are going on with the tacket agreements. As even Judge will point out later on, I don't know what you're saying to me. I don't know what a tacket agreement is. Do you mean tacit? It's adorable, but it's not.
Followed that proper procedure. You are unable or unwilling to abide by simple rules of civility. You interrupt, you don't wait for anyone to finish, and it will result with you being removed from the courtroom. So you are once again reminded of that. I'm going to give a little slack at the moment only because we are not in the presence of the jury. I'd like to go through a couple of things, the first of which is the jail attire. Mr. Brooks, we, meaning myself and the jail, have made arrangements by allowing folks to bring in street clothing for you. You've appeared previously in a suit and tie, very appropriate for a trial. If you no longer have those clothes available, the jail has a supply of clothes that they can also lend to an inmate. The reason we make those arrangements during trial, sir, is because this court has taken a number of steps to shield from this jury that you are in custody. Your hands are not shackled. Okay, there are skirts around each one of the tables. I'm aware of the feet shackles. That's yet another interruption. I'm aware of the shackles on your feet, and that's why the skirts are on your table and frankly, all of the tables, right? So that it appears to be the same for anyone coming in and viewing. Again, their arrangements have been made for you to appear in street clothes or civilian clothes. I would like you to appear in street clothes, and the reason why, sir, is to reduce or even eliminate even the appearance that you are in custody. And it is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
Mr. Brooks, I've had many trials with individuals who are in custody, and when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial. Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect, I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody. I think that's a well-known fact because it's reported on every day in the media. It's shown every day on the news where I am, what jail I'm housed in, and that I'm in custody. It's virtually impossible for anybody to not know that I'm in custody.
Mr. Brooks, did you hear the question that I asked you?
And I respectfully keep the position that I just put on the record.
Mr. Brooks, I will ask you again. Are you willing to go back to your cell or into the jail and put on street clothes?
I do not.
I want to notice a few things. First off, he's nervous. All right, he's very nervous because this is day 1 of trial. If you look at his arms when I hit the replay button, when you look at his arms, he is shaking. He's nervous.
He can't stop like bouncing back and forth.
But you'll see, actually, if you just look at his shoulders, look at his right shoulder. you will see it shake. He is
The dented one?
the dented shoulder. You look
Wanted to
at
make sure.
you look at his right elbow and shoulder. You can see it shaking. He's nervous. All right, he's about to go into trial, and he has no idea what he's doing, other than he knows he has to create the biggest disruption that he can create. All right, so and now bear in mind, he has been in prison now or in jail for a year. All right. This isn't withdrawals. All right. This is nothing like that, because we're talking, it's been a long time. This is not withdrawals or anything like that. He's literally nervous as shit. All right. But just keep an eye on his right arm.
Liz asked what he's charged with. We don't have all day, so give her the summed up version.
Oh, okay. Well, let's summed up version. Let's see. 61 counts of reckless endangerment and 6 counts of manslaughter, along with let's see, domestic violence,
Intimidation of a witness.
Yeah, intimidation, bail jumping. I mean, there's 72 total charges that went against this guy. He is in prison. He will be there for the rest of his life. Trust you me, he's not getting out. He's not going anywhere. We're covering in this case because I didn't have a YouTube channel when this case happened. But this was a big part of my life because I worked in the area. And so it did affect me at the time. I don't do that stuff anymore, but at the time I had interactions in the area. I don't do that type of work anymore. I do similar work, but just not in that area. Okay, so there we go. That's all I'm going to say about that.
Consent or agree to anything that you just stated, Your Honor.
All right, he did not provide an answer to a very direct question. Let the record be very clear that Mr. Brooks was given multiple opportunities to answer that question. And go back, Mr. Brooks, that's yet another interruption. I will advise you, sir, that at any point in time, if you wish to put street clothes on, I would give you that opportunity to do so. You've already heard it is my preference. You've already heard me advise you regarding the steps that have been taken to shield the fact that you are in custody from the jurors. You refuse to answer my question about whether you would go back to the jail. That's another interruption. So based on his refusal and his choice to come, that's another interruption. Based upon his failure to answer my question directly, I will take that as a non-response, but he came to court here today. That's another interruption. I will take that because he's come to court here today in his jail attire, that is a choice that he has made freely, voluntarily, and intelligently. No one has forced him to come to jail in those clothes. This court is encouraging him not to. He's appeared previously in his street clothes in what I would describe as a very nice suit and tie, but it is his choice to not do that, and we will proceed accordingly.
So while we're on the record, Madam Challenge, the subject matter jury.
No, you may not, sir. You need to file a motion in order to do that.
So
Mr. Brooks?
I haven't even been responded to. I gave.
Mr. Brooks, you're interrupting me yet again. All right, Mr. Brooks, you are now going to be removed to the other courtroom.
Do you think that at any point in this trial, after right now, do you think he's going to challenge subject matter jurisdiction, Ketchup?
Oh, for sure.
I would suggest
he was traveling, Jay. He wasn't driving.
He's going to challenge subject matter jurisdiction about 3,700 times.
Of course. It's rule number 1 in the playbook. Well, actually, rule number 2 after the special appearance.
And you people are going to sit through and enjoy every damn one of them, I tell you. Every damn one of them, you're going to sit through it and enjoy it and be like, well, we could be watching Fleabag shit, but here's this guy challenging subject matter jurisdiction, all right, after he ran over people in the same area that they told him he ran over people in. Just wait. Just wait till we get to his mom's interview. I'm going to share that with you too. His mom's interview. I have 3 of them. All right. I have 3 of them. Just wait. We'll get to them. We'll get to them. Oh my.
I have had a dozen or more interruptions. We will be off the record while we do that. Thank you,
I don't
everyone.
agree to a stop. I'll move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to.
No stop him. No stop him. He's
I have
got
right
the
to be present for
shackles
trial.
on his ankles. The shocks on his ankles. No stop him. Well, we're going to move on. All right. Take a little break here. All right. Now we're back here. We got Attorney Basie, Witcher. We got Hopper over there. And the judge is getting ready to go back on the record. Oh, I have to remind everybody of one thing. One thing, folks. At some point in time, the judge is going to say that this trial has been going on too long and going to ask things to be moved along. And Darrell Brooks will say, well, if it pleases the court, I'd have to say accordingly, it's apparently not by my doing. And the judge goes, I would have to disagree. Clearly, you have been the main reason why this trial has taken 3 weeks. Yes. But he's like, they said they would be done with their all of their evidence in 3 days, 3 to 5 days, and it took 2 weeks. So clearly it's not my doing. Oh no, sir. This was your doing. Gang gang.
Mm-hmm. This is gonna be a lot like the interrogation interview, right? I'm guessing.
Pretty much. It's gonna be rough.
You're able to see the screen, is that right? Okay. I'll publish that as well.
But hey, you got some eye candy, lady.
All right, we are back on the record. Appearances are as they were before. I need to make a record that at 8:30
What the hell?
court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks on every day that we have been in court since Monday.
What is happening
He has
here?
shown complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times.
Remember, Darrell Brooks got removed from the courtroom, right? So we had to pause for a sec. All right, the cameras went blank. Darrell Brooks removed his shirt. He fought with the police officers or the court people who were taking him out. Gang. All right. Then he removed his shirt. Now I want to make something very clear. Darrell Brooks has a scratch on his arm. Oh, he needs medical attention. Medical attention.
Is that why he's got his shirt off?
Oh, yes. Just Jay is telling you right now. He's in a lot of pain. He needs medical attention. Hi, Sticky. How are you? Hi, Sticky's here. Hi, Liz Barnes. He needs
Hey, Sticky.
medical attention. This is terrible. What's going on with Darrell Brooks right now? Whew. Hold on. I'm going to call in and see if we can get a surgeon in there.
Yeah, we need an ambulance.
Look at him. He has his shirt off in court.
What
His
an
tiny
idiot.
ladies are sticking out of his gel pants.
Do you think he regrets any of this garbage
Nope. He
that
loves
he did in court?
Nope. He put on a show. He put on a show.
Morning alone, he started interrupting this court within a minute of the court calling the case. I should also make a record at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting.
All right, Peculiar. I'm going to say this just one more time. They allowed this crap to preserve a record. All right, he's representing himself. They don't want an appeal to go through. They don't want him to cause a mistrial. They have to allow this bullshit. All right. Now, I honestly, I think she probably took it further than she had to. All right, but she was being very, very careful in this huge case to make sure that she preserved the record that he got a fair trial. All right, so that is why they went through all of these painstaking efforts just to make sure he got a fair trial. Okay, so that's why he's trying to make a mistrial any way he can do it. Okay, so that's what I'm trying to prove the point of. All right, so I just wanted to throw that out there for you, peculiar, of why they did this. Is this guy a relative of Webster Line? I mean, he might be. He might be Maestro. He could be. All right, back to it.
That at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items. I want to give him headphones since he has claimed in the past to be hard of hearing in one ear, but given his statement that he would throw and break things, unless he can pledge to this court.
By the way, we're on day one, folks. We're on.
Stop it. This is day one?
This is day one.
Oh, wow.
We're on day one. Oh. Okay.
That he will not do that. I'm not going to provide that information. I will advise that the audio in that courtroom should be turned up accordingly so that it is louder than it has been. I've also been advised that the audio and visual equipment is working in that courtroom. The deputies that are in there can see and hear the court through the Polycom system. Today is a little bit different in that there is no Zoom. And so, but this court, with the blessing of technology in this new building, have the ability to call in one room system to the other. That is why we're able to see and, when appropriately, hear him when unmuted. And then there are the 4 camera angles that are presently from this courtroom. I have the camera in the other courtroom on a single camera, since he's the only individual in there. This court has, in essence, extended this courtroom to the neighboring courtroom. While there is ample evidence in the record, not only through the proceedings up to this point, but this morning alone, that through his conduct, he has forfeited his right to be present. I'd also make a finding that he is appearing from that courtroom, and that because of the audio and visual equipment and system that we have in place, that it is the functional equivalent of being present in this courtroom. This court has relied repeatedly on Illinois versus Allen. I've read portions of that case into the record. I don't intend to go through that at length here today, other than to indicate that trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula exists for maintaining the appropriate courtroom atmosphere will be best in all in all situations. And in that case, there were at least 3 constitutionally permissible ways for a trial judge to handle a stubbornly defiant defendant, which this court would find Mr. Brooks squarely has become and has demonstrated over the course of these last few days. One option is to bind and gag him. I've already talked about at a previous hearing why I choose not to do that. Cite him for contempt. I choose not to do that either. The third is to take him out of the courtroom until he promises to conduct himself properly. Mr. Brooks today, of course, showed up in court from the jail in his jail attire. He does that by his choice. I gave him the opportunity to go back to the jail to put on his suit and tie or other street clothes. He refused to answer that question. This court will continue with this trial, as I have previously indicated. There are many resources that have been put into bringing this day to bear, and it is important for all involved that this trial continue. Again, Mr. Brooks is given the opportunity to appear from that other courtroom.
He's gotten
At this point, I'm still in the final housekeeping matters, and so he clearly has forfeited his right to be present for that. I will advise Mr. Brooks, as I have advised him repeatedly, if at any point in time he wants to come back and he is willing to promise that he will abide by the rules of courtesy and decorum and be civil and show respect for the court proceedings for all individuals.
All right, now this is important. This is very important, folks. All right? There are 92 of you still watching. This is important. Darrell Brooks right now is pointing out his major injury that occurred on his arm. All right? Remember, there was a scuffle that took place when the cops took him out of the courtroom prior to this and brought him into the neighboring courtroom.
Where's all the blood, Jay?
Oh, it's massive. Massive.
Because I don't see any blood dripping off or anything.
Oh, no, this is massive. I mean,
it's a gaping wound?
It's gaping. This is one of the biggest wounds, I mean, that's ever been seen. Grand Canyon of wounds. Right? He's pointing to of the ouchie that he got. I believe he called it an ouchie. He didn't call it an ouchie, but I believe.
I agree, Mama Bearly. I hope none of the aunties take their shirts off during their trial.
Oh, man. Can you imagine? I'm going to get a flea bag without a shirt, or a paint chips, or a flea bag without
any of them. I don't want to see any of them without a shirt.
I want to see all of it because you know me. I like to see disgusting, terrible stuff.
Yeah, you do.
That's why I'm watching this show here. By the way, folks, I don't know if you know this. There's a 50-50 shot. I believe Jeremy Hales might be on my Saturday afternoon show. I will be sending him a link. But I do understand he's busy because he has been getting pegged a lot by paint chips. He's been getting pegged and pegged and pegged. But he did say if he could get a break from his pegging by paint chips, he might pop on to the Just J Hip show on Saturday afternoon at 12:30.
Hopefully he can schedule you in between rounds or squeeze you in between rounds.
You squeeze me in between rounds. But I'm throwing that out there. I don't want to make it as a promise because, as you all know, Jeremy Hales is busy. But he did say, send me a link and I will see if I can get in there in between my peggings. That's basically a quote from Jeremy Hales. Send me a link. I'll see if I can get in there in between my peggings. Okay, so I'm setting that up for you for Saturday. I'm not guaranteeing it in my thumbnail. All right, but I'm just letting you all know right now. I believe there's a good chance we're going to have a Jeremy Hales interview. And we're going to find out how his pegging was. As only Just JF does the best interviews. As you know, the hard-hitting interview. Hard-hitting interview. Where we find out how...
Well, maybe you guys could compare notes, Jay.
I'll let him know how my pegging went. And let me know how his pegging went. It'll be the hard-hitting news that Just Hip always provides. Liz Barr says I need to see that email, please. I'll share it on Saturday afternoon.
You read it in the beginning, Liz. When this is over, go back to the beginning and you can hear him read it.
I can pull it up and read it. Hang on one sec. I will read you my email. Hang on, because I sent him an email. And I told him that he could join me on my show. And he said, I'm not sure if I can step away from my paint chips pegging on Saturday, but B-U-T-T capitalized. Send the link and maybe I'll get a break. Hopefully before your big rumor goes up. Oh no. Jeremy Hales is going to be involved in a big rumor. No, I can't. Thank you, Mama Bear. Much love. I appreciate it. Okay, but that's for tomorrow. That's for tomorrow. There's a good chance Jeremy will probably, maybe, possibly be on the show because we have to discuss our pegging and we have to see if his pegging was as good as my pegging. I don't think I can say that, Ketchup. we better get back to Darrell Brooks because he's heavily injured here. Look at it.
In this courtroom, including Mr. Brooks himself, then he may come back in. It's also my intention to give him that opportunity at each new stage. But again, we are in the
his pinky's injured.
Preliminary stage prior to the jury being brought in. I would note it's a little after 9:06 a.m. At all times throughout the court's statements thus far, since going back on the record, Mr. Brooks still appears to be communicating, or at least attempting to communicate with someone else. I can see his hands moving. He has turned his back. I can tell that he can hear me because he shakes his head no at a point in time where it's clear he's disagreeing with something that I've said. I believe he can adequately hear, and that his statement earlier in the proceedings that he's hard of hearing is simply another tactic of his to disrupt, to delay,
Why is he wiggling his butt?
Create chaos. I will further advise Mr. Brooks that his continued behavior, whether it be appearing in court in jail attire, whether it be causing disruptions in front of the jury, that he does all of those things at his peril. But I will, of course, take appropriate steps to limit what the jury can hear, if appropriate.
The smell of nicotine.
All right. I've received
Oh my God,
to
right?
reset the Polycom system, so I'm not sure what that means. I'll find out, and if appropriate,
nicotine and failure.
A record as to why. Whether that
There's no
impacted,
garage
anything that
door
was
to
happening
open
other
in the
room.
courtroom.
But at this point, while I'm not going to get off the bench, we're going to take a short recess for that resetting to take place.
I would request an opportunity for then, Your Honor, when we go back on the record, please.
Absolutely.
All right, well, we're going to take a little break. Just your hips going to pop forward because I don't do the breaks. Here we go. Let's see.
It's a great photo of him, though.
To do that every single day because I've noted a continuing objection. With that, you wanted to make an additional record?
Yes, Your Honor, it's probably appropriate at this stage. I did want to address a topic that's maybe not been raised in the courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Darrell Brooks to proceed to trial. The court is well aware that the district attorney has an obligation and a duty to rate any.
By the way, folks, I do intend to go until right around noon today, right until noon. And then we're going to pick things back up on Sunday morning. Once again, on Sunday morning, there's a good chance I'll probably give you a little bit of a Fleacap if they do some stupid stuff on Saturday night, of course. But I will probably do more Darrell Brooks on Sunday, and then Monday we'll do our get back to our Monday respun day thingy, as we call it. So we're going to do that on Monday. So no, but I do want to continue with this trial because it's important to me. All right, I know it might not be a big win for all of you because it was 5 years ago. Actually, well, it was 4 years ago when the actual trial occurred. But yeah, I just want to. This is something that's important to me, and that's why I'm sharing it. It's not about views. It's not about anything like that. It's about me watching a show or watching a trial that's important to me. Okay, so I just want to point that out. But I'm going to go until about noon. So I got about 41 minutes that I'll continue on. Okay.
Concerns as to the competency of any defendant to proceed to trial. Any counsel representing Mr. Brooks would have that same obligation, and the court itself, if it had a concern as to the competency of any defendant to proceed, can request an evaluation that's pursuant to 971.14 of the Wisconsin statutes. At no time has anyone involved in this case had a competency concern. And I say that based on the fact that Mr. Brooks has made multiple court appearances, most of them before Your Honor, but at least initially he appeared before two court commissioners. He's had counsel representing him up until last week on this case. And you've made a record with Attorney Perry previously as to Mr. Brooks' ability to understand what's going on and his ability to participate in his own defense. You made a thorough record last week when you went through his waiver
Thank
of
you.
right to an attorney and his absolute desire that he expressed multiple times to represent himself. I would also add.
Hey, what are you doing? Why am I getting the circle willy thingy?
I don't know what you do, Jay. Stop destroying the show.
He is coherent. He is intelligent. He knows the issues in the courtroom. He discusses what happened in court that day with these individuals he's speaking to.
We're back.
I am thoroughly convinced, Your Honor, that Mr. Brooks is 100% competent to proceed to trial, that his mental capacity is not reduced in any fashion. Anybody that thinks otherwise has no involvement with this case. I would reference the court to today's filing, which Mr. Brooks provided. It is extremely well written. His handwriting is immaculate. It's perfect. The punctuation, the grammar is 100% accurate. He drafted this himself in his jail cell last night, I presume. Maybe it was this morning. He has continued with the same objections that he has been making repeatedly in this case. So he clearly understands the issues. He understands the defense that he wants to pursue. He undertook the effort to have this form notarized by a jail employee so that it is a signed and sworn affidavit. Absolutely no concerns on the part of the state of Wisconsin that Mr. Brooks has any deficiency in his competency. We are 100% convinced that these actions of Mr. Brooks are deliberate and intentional, and they have escalated. And the court has seen this since August 25th or so, as the motions were decided by the court, most of them to his detriment. His behavior became more and more difficult in the courtroom. It started out less aggressive with him sleeping and asking to be able to leave the courtroom. Then we had a toothache. Then we had a situation where he didn't want to come to court, was refusing to come to court. The record will be clear, Your Honor, that each time, and the Sheriff's Department has done an absolutely fantastic job dealing with Mr. Brooks fairly, professionally, respectfully at all times. We concur 100% with the record you just made as to what happened after the recess at about 8:42 this morning as to Mr. Brooks' conduct. These are deliberate actions on his part as we get closer and closer and closer to actually presenting this case to a jury, that he is attempting to derail these proceedings and avoid the inevitable. And I want to make that record. I tell this court as an officer of the court, we have zero concerns as to the mental competency of Darrell Brooks to proceed. And we have had many, many dealings with him on the record and off the record that I base that on. I also wanted to add one other comment as to the court's record as to the need to proceed with this trial. We concur 100%. We would also note it's not just a matter of resources. It's the need to proceed to justice. It's the need to get justice for the crime victims who have patiently attended every one of these hearings. They have a constitutional right to trial. They have a constitutional right to a speedy disposition of this case. And that doesn't mean hasty. That doesn't mean reckless. It means efficient administration of justice. And this court has provided that to the crime victims. And we think that's another reason that Mr. Brooks' antics, which is all they are, clearly speak for themselves. This is not his inability to understand what's going on by any stretch.
Thank you,
he
Attorney Knopper, and I do
understands.
appreciate you raising that with the court
Just a
because
game.
I share your.
Yes, they understand what's going on, but they want to make sure they have a fair trial. They're going to work very hard, and it sucks, actually. This entire trial sucks because they work, I would say, beyond the realms of a fair trial. They go out of their way so far to make sure that he gets a fair trial that it's painful, actually. But that's why I'm watching it. I live this, all right? And you live this, Ketchup. You were there.
Yep.
I worked there. Well, I did. I worked here from Omaha, but I worked there in terms of, we had to talk about moving property out of the area while the trial was going on. At the same time, there was so much other shit going on. You had Rittenhouse going on. All right. You had, because that happened during this whole ordeal. You had Rittenhouse. We had George Floyd that happened prior to this. It was it was a
It was
bomb.
unbelievable.
Yeah, it was a bombshell in the area that had taken off. And it was really hard for everyone. But no, I caught on. And the reason that this trial was huge for just your hip was because I could say myself, but I throw myself in the third person. But the reason is I started watching people like Law Talk with Mike. All right. I was not on YouTube really before this. I'm talking even watching YouTube. I didn't do it. But I started watching this trial. I started watching Law Talk with Mike, which led me to other people like eventually Megan Fox and Tug and Legal Vices and Rosalind Duke. And then Rosalind Duke started stalking me, and then she fell in love with me, and she was like, I love this chap. He's so wonderful. I want to adopt him and bring him into my home, and take care of him because I so love just your hip. And that was what Rosalind Duke said. That was Rosalind Duke. And then, anyways, this trial led me to actually starting a YouTube show myself. And that's why I'm sharing it today. All right, so there you go. The backstory.
Observations that you've just noted on the record, I would adopt them fully as if they were my own and make them part of the findings that I've already made on the record. Obviously, I personally haven't listened to the jail phone calls that you referenced, but I do take your statements as an officer of the court. I look forward to further reviewing them, if need be, changing any conclusions that I've reached here today, and I would require you to file that exhibit so that that can be part of the record as well. I would also add to what you have just stated. This court has read through not one, not two, not three, but 4 evaluations related to the special plea that was withdrawn. And those are very recent evaluations where the examiners met face-to-face in the jail or in an appropriate visitation room with Mr. Brooks, either in July or August of this year. And every single one of those individuals did a mental status exam that's noted in their reports. Frankly, the behavior that we're starting to see here is no different than some of the behavior that was noted by those examiners as well. This behavior is frankly more in line with someone who's defiant, deliberate, and in line with the conclusions related to whether he suffers from a mental disease or defect that would qualify for a special plea. I've not gone into much detail, and I won't. Those documents are part of the record, but it's very clear to this court that everything that he has done, as outlined by the state and as made evident on the record of these proceedings, that it is the sole intent of Mr. Brooks to make a mockery of this process. And I've stated, and I'll state it again, I'm not going to tolerate it, but there is I believe this trial needs to continue, should continue, not only for Mr. Brooks as the accused, who also has the right to a speedy disposition. He hasn't exercised it. The victims have a right to a speedy disposition. And it's important for the justice system to go forward with this proceeding. We are at the stage where we are at with Mr. Brooks muted in another courtroom because of his defiant actions. No one else. And I appreciate everyone's patience as the court goes through these things. Frankly, it gives Mr. Brooks time after time after time to conform his conduct to the clear expectations, but he just simply flat out refuses to do so. So what I'd like to do is finish with the approval of the jury instructions, the preliminary jury instructions. I will make a record that Mr. Brooks did not file anything in writing regarding a proposed jury instruction, as he was advised to do yesterday. If he wanted me to consider something, I believe we had a very clear discussion on the record about that. He was given a full copy of the draft preliminary jury instructions. He was part of that conference that we held yesterday. There was even a discussion regarding where he could find jury instructions with the legal materials that he has access to in the jail. Although he didn't take it to his cell yesterday, he has had the selected statutes that I referenced yesterday that also have the rules of evidence. And so I wanted to make that record. I don't have anything from him this morning regarding any additional jury instructions. Has the state had an opportunity to now review the preliminary jury instructions with all the changes that were made yesterday?
We have.
Any objection to those?
No.
All right. Mr. Brooks, I'm going to unmute and ask you if you have any objection to the jury instructions that were provided to you yesterday. I'm specifically looking for a yes or no.
Okay, this is gonna go well. This is going to go well. She's going to ask him if he has any objections to the jury instructions.
Mm-hmm.
How do you think this is going to go, Ketchup? On a scale of 1 to 10, 1 being smoothly and 10 being, oh my God.
25?
25 as in holy shit, really? Here we go. It's gonna go smoothly. I'm gonna let this play on. I'll be listening in. I have to get some ice, but I'm gonna play on for 30 more minutes just to have to be on until noon because I have to go back on with People Watch tonight at 8:45 with Starcasm and Ketchup, of course. And so yeah, we have to be back for that, of course.
Yep, and JJ needs time for a nap.
And JJ needs nap time. Miyagi, I scratched your belly enough. Miyagi wants to put me to bed already. It's okay. Here we go. I'm gonna leave you with this. Let me unmute. Let me pause this. Here we go.
Or no answer, and I'll address further if need be based upon that yes or no. The microphone is unmuted. Actually, we'll need to turn him up. It's not very loud on our end. Mr. Brooks, did you say one more time? Yeah, but you know what? Your volume's a little low, so we're gonna have them adjusted over there and in here. So give us a second. Where is the microphone? It looks like it's in front of the monitor. Mr. Brooks? Try again.
Am I on the record?
You are on the record. Ooh, that's loud now. We'll turn ours down. Mr. Brooks, yes or no question, do you have any objection to the preliminary jury instructions that were provided to you yesterday? Go ahead, answer, please. All right, your objection is noted for the record, and I'm just putting the mute back on. He provided that objection without any legal basis. I muted him just so I could ask this question. I'll be right with you, Captain. Mr. Brooks, do you have a legal basis to object to those preliminary jury instructions? I'm unmuting you. Hold on, the volume is not being appropriate at the moment. Try it again, sir. I apologize for the technical issue. All right, the technical, we're gonna have to figure that out. It's not appropriately working. I do appreciate that he was able to hear me because he leaned in to answer. So I just wanna make that record. I'm gonna go take a recess. I'll just mute while we're doing that, just so I can figure out what the audio issue is, and then we'll go from there.
All right, just J-Hip won't leave you hanging. Hang on 1 second here. So, try and get our technical issues worked out.
With the jury instructions, Mr. Brooks, you indicated you had an objection. My next question to you is, what is the legal basis for the objection? I'm going to unmute so you can answer. Go ahead, sir. You need to turn around so I can hear you. Part of the issue is he's also not facing the microphone, and so I need to hear him, and he needs to turn around. Mr. Brooks, I'll ask you once again, what is the legal basis for your objection to the jury instructions? I'll ask a third and final time, sir, what is the legal basis for your objection to the jury instructions?
I wasn't loud, and I can't even hear what she's saying all the way, man. It's too low.
You want your headset?
Mr. Brooks, I can hear the deputies over there. I know they can hear me. That's been confirmed. There is the headset available to you should you wish to use it. If you can't hear, I would ask that you put them on.
You just put it down.
I'm able to hear. He said to the deputy, put them down. I don't want them. All right, I'm going to mute once again so I continue with my record. He did not answer the question, what is the legal basis for the objection? I asked that question 3 times based upon that non-response. His objection is noted for the record, and I will approve the preliminary jury instructions that are on file with the court. Obviously, they'll be uploaded once I read them, but all parties have been given copies of those. Before I turn to the motion for reconsideration, you raised this earlier, at least the topic of it. Mr. Brooks presented a filing to the court this morning. I asked the bailiffs before the case was called at 8:30 if Mr. Brooks had any paperwork and to ask him if he had any filings. He then provided this piece of paper and it was photocopied. Actually, it was date stamped, then photocopied for the parties. It may have already been scanned in, I'm not sure, but it certainly will be. I've had an opportunity to review this document. Based upon my review, I don't believe any response is even required. It's his affidavit. He's providing certain disclosures, but there's nothing about that that requests any relief from the court. Certainly no legal statutes or constitutional provisions are referenced. To me, it just looks like an objection that he's filing, and that will be, of course, noted for the record. Attorney Opper, anything you would want to add to the record on this, any position you are taking?
No, I also viewed this as, because he labeled it objection by affidavit, I think my interpretation is he was trying to make a record for appeal that he objects to the court's previous ruling. I don't think there's anything the court needs to do with this document at this time.
All right, thank you. Then we'll move on to the motion for reconsideration. And again, I'm keeping Mr. Brooks muted so that I can get through this process orderly, efficiently. When necessary, I will unmute him if the court has questions. All right, Attorney Opper, I have read through the motion. Is there anything you want to add to what you have put in your filing?
Only one other observation, Your Honor, that since I filed that the events of the last couple of days, I think further support my request. Not that the defendant's behavior in the courtroom has anything to do with the broadcasting of victims and witnesses, but I think the stress that is going to be placed upon them potentially by Mr. Brooks' behavior will be additional challenge to them as they testify. And so not having their faces displayed, I think, would help ease some of that tension for those individuals.
Mr. Brooks, my first question to you is, do you have a position on the state's request in their motion for reconsideration? I'm looking for a yes or no answer. If you, I'll unmute and provide that to me. Go ahead.
I didn't hear what they said. I just put the headphones on, so I didn't even hear what she said.
Sir, it's a written document that was filed, and you were provided a copy of that yesterday. We took a recess yesterday so it could be served upon you. If you haven't read it, that's your choice. What I'm asking you is, do you have any position on their request for this court to reconsider the denial of the state's request to prohibit the photography and video recording of victims and witnesses, and specifically their faces, while they testify?
A ruling was already, we already talked about that. You already ruled that the victims and witnesses will be shown. That was already ruled on.
You are correct, but they filed a motion for reconsideration. That's the document that was provided to you yesterday. I'm asking if you have any position on the request that I reconsider my ruling.
Yeah, it was everything's supposed to be public. This is a public trial. I don't understand why there would be even the need to reconsider what you already ruled on at this point, as far as to that particular issue. It's a public trial. It's a public trial. Anybody can essentially watch the trial. And like I said, as far as with the technology that we're in now, if they have to be sworn in by name, that in itself makes them easy to, if somebody wanted to pull them up or find them or find out who was testifying at any given time testimony is given, it'd be pretty easy for them to be found and to be seen. So, I mean, that's just the age we're in anyway, as far as with social media and Google and all these different things. We got all this technology basically at our fingertips. So I don't understand how it needs to be changed at this point when it was already ruled that this is a public trial. There's going to be a lot of things that are going to be shown. Why not keep everything public the way that it's intended to be? And because of the fact that you've already ruled on it, made that on a record, let's keep it the way it is.
All right, thank you, Mr. Brooks. I appreciate your legal analysis of that and your factual analysis of the prior.
Legal analysis.
That was actually a semi-coherent answer.
Legal analysis. Moo. Now, I want to keep in mind, over his right eye is a tattoo that says moo. This is related to, I believe, one of his family members who had passed away. So he got a tattoo over his right eye that says moo. Well, this isn't going to come up in court all that much, but I'm going to make the point that that's what his tattoo over his right eye says, is moo. There we go.
Ruling that this court gave, I thought you did an excellent job making some very good points, many of which I relied upon previously. There is a mechanism in the law for a party to bring a motion for reconsideration. Essentially, it requires that the party bringing the motion provide some new information or rely on an argument that the court aired as a matter of law in its prior ruling. The decision that I made previously and the decision that I make here today is one that is vested with the sound discretion of the court. I would note the state does rely upon a case. The case is not new, so it's clearly something that was in existence at the time of the prior motion. That's Estes versus State of Texas. It's 381 U.S. 532, but I would note it's from 1965. In 1965, I would say even in the 1980s here in Waukesha County, there was really a presumption that cameras not be allowed in courtrooms at all. We have moved vastly away from that over the course of the last couple decades, and certainly since 1965. I am certainly mindful of the potential stress that it may cause for victims and other witnesses to come into court and testify and to have their images broadcast as this trial is broadcast, not just locally, but nationally, and frankly, anywhere in the world anyone with a computer would want to watch. I would note, though, that prior to the point in time when this case came to trial, this court took significant efforts to keep victims' names private. There's a victim key that is on file. This court signed an order and even required Mr. Brooks to not disclose that information. That was one of the conditions set when bond was initially set. Now, that was by court commissioner, of course, but that's still a ruling that this court adopts. In addition, I believe I've done, up to this point, everything that I could to preserve their privacy. I don't frankly want to create an issue that could be an appellate issue. I think this potentially could be that if I limit the capturing of victim and witnesses' images. I'm aware of Marcy's law, certainly aware of the provisions that the state cites, but the fact remains the time has now come for this trial to be conducted. This is a public trial. The right to a public trial is not only for the defendant, but the state, but the public. All of the names are a matter of public record. This court obviously went through all of the names of the witnesses during the jury selection process. In the jury instruction, the names of all the victims will be read. The state agreed that it was time to put that information in a public document and on the record because the time for trial has come. The cameras in the courtroom not only facilitate the viewing of a public trial where anyone could walk into this courtroom, space permitted, to watch, but it facilitates victim rights as well. And that is because there are a large number of victims in this case. This court could not have all the victims and the public and the media who wanted to be here present. Frankly, I think it's because of how this court has allowed the proceedings to be live streamed that we don't have even a full courtroom here today. There is no doubt this case has received great public interest, but this is a case that the state brought charges, and rightly so. I understand it won't be easy, it may be messy, it may even be stressful, but it's important to the integrity of these proceedings, the perception of how things are conducted in this courtroom, that all witnesses, that all victims, with the exception of the one thing I accepted previously, be viewed in its fullness to the public. I maintain the exception for juvenile witnesses. They are in a special category as minors, and they, of course, if and when a juvenile witness testifies, may only be captured from the shoulders down. Their faces are not to be broadcast. Again, I am not unmindful of the impact, but in my...
All right. Now we're going to kind of pause here, but I'm going to show you Dawn Woods. All right. This would be Darrell Brooks's mom and her response to, well, yeah, we're going to do that. And I'm going to pop in occasionally and show a few of these things. I'm going to sign off here shortly, but I want to share this little portion. This is his mother, and she's now surprised by the verdict. Why? Because she's also a terrible person. All right, so I'm going to share this right now before I sign off. Here we go.
Darrell Brooks's mother is sharing her opinions on the verdicts today. 12 News' Caroline Reinwald spoke with her, and she joins us now live. Caroline.
Joyce, she tells me the trial has been difficult for her to process. She also says her son is mentally unwell, though she did share her thoughts for the victims and their families as well.
The hate was stopped. The hate mail was stopped. The hate emails that I'm receiving was stopped, you know, and people's hearts began to heal. My heart still goes out to the family. My condolences to all of them, but I hope that they can begin to heal.
Dawn Woods, the mother of Darrell Brooks, says she did not watch the verdict live today, but learned from loved ones of her son's conviction and says she's not surprised. When your son said that he didn't mean this wasn't intentional, did you believe him?
I know my son. I know it wasn't intentional. People who are mentally ill need help in the community, family, loved ones. The court system need to give them the help that they need.
This woman is sick.
What an enabler.
Yes. I have never met, other than Darrell Brooks, his mother is one of the sickest people that we're ever going to come across in this court case. Let's wait when we get to closing arguments, and then when he has victim impact statements, and then he has people speak on his behalf. His grandmother, his mother will all talk about mental health. He ran through a parade route. He ran over, all right, 70 plus people. All right. I want to keep something in mind here. The prosecution team only prosecuted him on physical injuries that were occurred. All right. They could have prosecuted him on many others, but they didn't need to. They knew what they had in front of them, so they took the physical injuries of the people who actually went to the hospital, and they actually focused on major injuries. All right, so if you want to talk about, maybe someone has scuffed up elbow, no, they focused on the major injuries. All right, and D-Bag Brooks, all right, actually brings onto the stand as one of his witnesses. He actually brings onto a stand a woman whose 4 children were ran over by Darrell Brooks, that the prosecutors did not want to bring her on because of the emotional trauma she'd already been through. But Darrell Brooks had no problem bringing her on the stand. Trust me, this does not go well for D-Bag Brooks. All right? It does not go well at all. But
and her excuse is bullshit because he ran. Okay, even if he was like confused about the barricades, which are put all the way around the whole parade route and on the blocks, like one block surrounding that, there's an additional barricade posted at those blocks. So just in case you weren't sure that after he ran down the first one, before you hit the parade, there's a second barricade. And then after he hit the first person or a couple people, he could have stopped, but he didn't.
I mean, there is so much evidence in this whole trial. And it's why this was a big trial for me. All right. It hit home from my heart because he avoided vehicles to run over people. All right.
Right.
That's how
he did.
Terrible it was. There was vehicles in front of him in the parade, of course, and he avoided those vehicles in order to run over more people. It's terrible. I'm going to cover this because it's what I want to do. I'm not concerned about views or super chats or anything else. I'm covering this because it's what I want to cover. I have a lot of insight into this, and that's why I'm doing it. All right. So it's not everybody's deal. It's not everybody's gig, but I like to cover things that interested me and that I had a stake in at the time. All right. So that's what I'm doing. I'm going to finish out Dawn Woods here, and then we're gonna sign off. We're gonna sign off, as Bone Crusher would say. But let's.
Now, Woods tells me that she did speak with her son today, though she would not tell me exactly what they talked about. She says that needs to stay between a mother and son. Joyce.
Caroline Reinwald reporting live. Thank you for that.
That's very true. Very true. There is a lot to come out. A lot will come out actually in the final reading when the judge makes her final decision. This is horrible. She reads off the phone contacts between Darrell Brooks and his mother and others. She reads off. And Darrell should know. He's been in the system many times. Darrell should know that all of these conversations are recorded. Yet, he says the shit he says.
When you get on the phone, anybody that calls somebody from jail or gets a phone call from jail, it says immediately on the recording, this call is being recorded.
And he focuses all of his conversations on the domestic. None of his conversations are focused on running over 72 people. Nope. It's all focused on the domestic and Erica Patterson. All right. That's all he's concerned about the entire time. And trust me, Judge Darrell, she's going to reveal it all and read it at sentencing. All right. It's frightening, amazing, and it's everything we would expect it to be. I will continue my coverage of this case. I hope you enjoyed it. I'm having a good time with it. And it's something that's important to me. And I hope it'll be important to you as well, or at least you'll enjoy the coverage because, well, it's what I do. I don't want to spend 7 days a week focused on the Jeremy Hills case. I love that case. I love those idiots. I love those morons more than anyone can expect. All right. And actually, I do consider Jeremy Hills a friend. All right. Same as Megan Fox and Tug and Rosalind. They're my friends. But I also like to do things that are a little bit different. All right. A little bit off the cuff. Something that's older. I do like going back to old cases and just following things that are important to me. And I hope they're important to you, or at least you just enjoy the coverage or the insight that I can provide. Thank you, Krusty Witch, and thank you, Softly Spoken One, Peculiar.
And it's crazy to me because I avoided watching any of this.
Yeah. And that's the thing. Some people never saw it. Some people didn't want to see it. But now that time has passed, it's a little easier for people to see it. Hang on, I got to write down where we're at in the case. Let's see, we're at 136. 136. Okay. I don't want to lose our spot because I am going to continue. And like I said, I am going to go through start to finish. It might take a little while, all right, because I can only do this 1 or 2 times a week. I'll try and give you a Fleacap in the middle of my coverage, all right, but at the same time, I want to also, have fun with you folks and make fun of Darrell for being stupid Darrell, all right? I love you all. Thank you for being here. I'll see you again in like 8 hours or something like that. I don't know. I'll see you in 8 hours or so for People Watch. Have a wonderful day. Be safe, you fine folks. Be safe out there. All right. Have a wonderful day. I love you all. Thank you for joining me, Ketchup. I appreciate that.
Of course. No problem.
And your sound has been so perfect.
I know.
Yes, you got your new iPad. And
It's amazing.
No longer can Ketchup destroy the Just JF show. No longer.
No longer can you blame me for destroying the show, is what you meant to
No
say.
longer blame Ketchup anymore. No. Ketchup's wonderful. Much love to Ketchup. Thank you for hanging out with Just Your Hip. And thank you, all of you fine folks, for hanging out with Just Your Hip. Hit that like, hit that subscribe. And also, just tell me how much you love me. All right. As we say when we end our shows, Ketchup, you first.
All the best.
All the best.
Hey, it's hip to BJ.